that to the Michigan State Police Crime Lab for analysis.
And while you may have learned about this, creating an alternative known source of DNA, this procedure of you gaining people's DNA through a buccal swab, that's not unique to your training experience.
It is not.
Okay. And we heard some testimony from most of the witnesses. They all consented to having that done without a search warrant.
That's true.
And that information, and I think you already said it, was transferred to the Michigan State Crime Lab.
Correct.
Now I want to talk a little bit about the cigarette butts that were seized out of the Trans Am. Okay. When you reviewed this case, did you notice that there were, Michelle, do you want me to take a break? You noticed that there were some cigarette butts seized out of the Trans Am.
I did, sir.
Okay, and we heard testimony that the 6 cigarette butts that matched the defendant, and then there was a 7th cigarette butt. Is that correct?
That is correct, sir.
Okay, and we have the 6 in evidence. I want to show you people's proposed exhibit number 100. Ask you to look at that, please.
This would be the 7th cigarette butt.
All right, now we heard testimony of the 6 cigarette butts. Why don't you tell us about this last 7th cigarette butt?
Looking at the property logs, this cigarette butt was collected from the vehicle and was in with some other items, matchbooks. Subsequently, it was removed from the other items and also forwarded to the Michigan State Police Crime Lab for analysis.
And is there something different about the location of that one versus the other 6?
On the property receipts, the 6 cigarette butts showed the ashtray, and the property receipts, this cigarette butt did not indicate where in the vehicle it was found.
You are moved to the admission of People's 100.
No objection.
Or would admit people's 100.
We also heard testimony from Detective Miller about seizing a shovel handle from the trunk of the Trans Am. Do you recall that testimony?
I do.
Have you had a chance to review the evidence log and determine the location of that?
I did.
Okay. I'm going to show you People's 101. See that?
I do.
Oh, go on.
So I get close to
Yes.
this. This would be the shovel handle that was recovered from the trunk of the vehicle. The second item that was in the bag was the original property tag that was on the shovel handle. It's initialed with RM. I'm familiar with those initials of Detective Richard Miller. And it indicates from the trunk of the 75 Pontiac Atwood's vehicle, written on the shovel handle.
And you've had an opportunity, I know we pull it out of the bag like a big surprise. You've had a opportunity to view that in your review of this case?
I have, sir.
Okay, and you heard Detective Miller testify about seizing that, is that correct?
I did.
Okay. Tell us a little bit about the original property tag.
The original property tag is authored by Detective Miller. His name is on the bottom of it. And indicates description, wood handle section, broken from original handle, a trunk of 75 Pontiac Trans Am, and got the Rockford post.
I move for the admission of People's 101.
No objection.
Court would admit 101.
And we heard about some of the scientific evidence, obviously through several of the witnesses. And we heard a little bit about fingerprints. Were there fingerprints that were attempted to be obtained from that Trans Am?
Yes,
Okay, and what is your understanding of their value?
they were not able to make any matches based on the latent prints that they had. They contacted the Michigan State Police Lab, I believe it was in 2015 or 2016, to check to see if those prints are suitable for comparison, and they were not suitable by today's standards.
Is that uncommon?
Correct,
Sometimes they match, sometimes they don't.
sir.
Would you say more frequently they match or don't?
They do not match more frequently.
And we heard testimony about liver cells on the tissue, the spray bottle within the trunk of this car. Recall that testimony.
I do, sir.
Were there attempts to locate the rest of Rick Atwood's body?
There was.
Okay, why don't you explain to the jury what attempts were made?
The area referred to as the 800. There were aerial searches, foot searches. There was also, during the course of the investigation, there were canine cadaver dog searches. The cadaver dogs will indicate on human remains, and additional foot searches as well.
And never were able to locate what you believe to be Rick Atwood's remains.
Correct, sir.
Now, can you explain what the National Missing Persons Program is?
It's a program through the University of North Texas. It's a database for all unidentified human remains.
So you send some information to them, they keep it in a database, and if they find something, they contact the investigating agency.
Correct.
I'm going to show you People's Proposed 102. Ask you if you recognize that document.
I do. This is a submission form for the evidence. Property item is being sent to the unidentified human remains submission, University of North Texas.
Your Honor, I move for the admission of 102.
No objection.
Court would admit 102.
And since that submission, has you or the Michigan State Police received any information from them that indicate that they have found Rick Atwood?
No, we've not received anything.
Do you recall testimony earlier about the registration card from the Gateway Motel on August 10th, 1983, room 20?
I do.
Again, we have the card indicating Mike Roberts Jr. and a address, Trans Am, date, cost, some other things there from the Gateway Motel, correct?
Correct, sir.
Did you have an opportunity to try to determine whether 1894 Main Street, Cleveland, Ohio is a real address?
We did. During our cold case investigation, we contacted the Cleveland Police Department, and they indicated they have a main street, but the numbers do not go that high.
Now, we have this zip code, 45244. Did you make any, did you determine what area that zip code is for?
Yes, we did. We checked the zip code, and that came back to Cincinnati.
Cincinnati, Ohio?
Correct, sir.
What connection did your investigation bring up about Cincinnati, Ohio and the defendant?
Mr. Snell's mother lived in Cincinnati, and also from conversations, Roy Snell lived there at one point as well.
You also recall testimony about the long-distance telephone traffic sheet that I call the call log that Detective Miller seized during those same dates. Do you recall that?
I do, sir.
And specifically on that, I think I have, oh, I don't. Specifically on that call log, there are two numbers associated with room 20. Is that correct?
That is correct.
Okay. And what were those numbers?
First one is 689-1786. The second is 689-6163.
Okay, and then that's about halfway down there, or no, about a third of the way down?
It is, sir.
I'm going to try to locate that actual document. Your Honor, can I publish 98 to the jury?
You may.
Again, about 8 lines down. Is that correct? I don't know how that did that. Oh, you. All right. Yeah, the technology is hard enough. Thank you.
That'd be 8 lines down.
I can publish this?
Yes.
And 689, those are the first 3 numbers for what area?
The White Cloud area.
To this day, correct?
It is, sir.
So I first want to talk, you did a search warrant was conducted for the subscriber records for those 2 numbers. Is that correct?
It was, sir.
Show you people's proposed 103 and 104. Ask if you look at those quickly, and I'll ask you some questions.
Proposed People's Exhibit 103, I recognize as the subscriber information for 689-6163, Charles Brown. Proposed Exhibit 104 is subscriber information for Roy Snell, 689-1786.
All right. Your Honor, I move for the admission of people's 103 and 104.
No objection.
Court would admit 103 and 104.
Leave that right here for a second. So I want to talk about, I'm going to do this first. Were you also able to obtain a phone book, a 1983 phone book from this says Fremont area, and includes White Cloud?
We were.
How did you obtain it?
Request out on Facebook.
Yeah. Someone provided it to you?
Yeah, they did.
I'm going to show you people's proposed 105. Does that look like?
That is the phone book that we obtained for the years 1983 and 1984.
And there are some pages on there that indicate these phone numbers. Is that correct?
There is.
And I'm going to show you 106 and 107. Is that a copy of those pages?
It is,
And those pages are tabbed in here as well?
they are, sir.
Your Honor, I move for the admissions of people 105 through 107.
No. Court would admit 105, 106, and 107.
Let's talk about 689-6163 first. Who was the subscriber information to?
Charles Brown.
And does the subscriber information also indicate the address?
It says Rural Route 1, Box 27, White Cloud, Michigan.
Were you able to ascertain where Charles Brown lived?
We did. He lived in the White Cloud area on 1 mile. I don't recall the exact address. It was 17, that's a 4-digit number, started with 17.
And did your investigation determine if Charles Brown and that residence had any connection to the defendant?
We did.
And what was that connection?
The girlfriend for Roy Snell Jr., Nita Mackey, her mother lived at that address.
I want to talk about 689-1786. Did you obtain from your search warrant and also from the records in the phone book what name and address was associated with that phone number?
It'd be Roy L. Snell, address of 5811 East Baseline, White Cloud, Michigan. Would be the father of Roy Snell Jr.
So that's the father.
Yes, sir.
And the call log, you don't have it anymore. Go back to the call log for a second. If you could.
It's right here.
Is everyone with it?
Yeah.
Heard some testimony from Gail Rushlow regarding the length of time that is also indicated on that call log. Does it indicate how long the calls were for?
Looking for the first call to 689-1786 Roy Snell was 10 minutes.
And the second call?
Number 2, 689-6163 Charles Brown, 1 minute.
Switch gears a little bit. Talk about Nolan Gant. Did you have an opportunity to re-interview Nolan Gant?
We did.
Okay, and where did that happen?
The first interview would have been at the Tennessee Department of Corrections.
And when you first made contact with him, were you aware of his previous statement in 1985?
It was.
And did you make contact with him you already said it, but to discuss that statement?
We did.
Okay, and about what year was that?
It was 2015 or 16, one of the two.
And at the time, you were aware of the 1985 statement and its level of specificity, is that correct?
It was, sir.
When you spoke with Gant originally in Tennessee Department of Corrections, could you describe his level of cooperativeness?
It was clear he did not want to be involved. We went over the statement. He indicated everything he said would have been the truth. However, it's clear he didn't want to be involved.
Okay. But then on the strength of that 1985 statement, he was eventually put an investigative subpoena, and he's testified at preliminary examination, and now he's testified at trial. Is that correct?
That is correct, sir.
And specifically, you've heard him testify that he shot and killed a white guy and took his money, drugs, car, and the car was a Trans Am. Is that correct?
Correct, sir.
Okay. And that he shot the victim while he was in the driver's seat,
Yes.
and they put the victim in the trunk,
Yes, sir.
buried the guy and gun on his private property,
Yes.
stayed at a motel in Grand Rapids,
Yes.
called a tow truck to tow the car.
Correct, sir.
Did this happen in 1983?
Yes.
that he was in an adjacent cell with the defendant,
Correct, sir.
and the defendant used an alias.
Correct, sir.
And as the lead investigator in this case, you would agree that that statement matches up with the evidence.
It matched up with the evidence as well as other witnesses' statements that we received.
And that's why you went down in 2016 or 17 to talk to Mr. Gant.
Correct, sir.
Okay. And again, switch gears again. We stated earlier that there was an extensive physical search for the body of Rick Atwood, correct?
Correct, sir.
And did you make any attempts to check records? How do I phrase this? The records that people leave behind when they are in society.
We made numerous checks of various records in order to identify if Richard Atwood was still alive.
And as a police officer, you have training looking for these types of records.
Correct, sir, we do.
I'm going to first show you People's Post 108. Are you aware that the Department of State has a record for whether people have obtained a passport?
Yeah,
I'm going to show you People's 108. Was that the response you got from the Department of State?
this is the response we received from the Department of State for Richard Atwood. Indicating that there's no passport found for Richard Atwood.
I move for the admission of 108, Your Honor.
No objection.
Court would admit 108.
Okay, and before I continue, sometimes when you make inquiries of this record, sometimes you get a document back, sometimes they just tell you there's no record. Is that correct?
That's correct, sir.
So during the search process, sometimes you got a document, sometimes you just got, there is no document.
Correct.
Now the defendant had to pay some child support down in Kent County, the deceased, Mr. Atwood, had to pay some child support in Kent County, is that correct?
He did.
And did you inquire as to whether he had been making his payments?
We did make that inquiry. His last payment was made on August 2nd, 1983.
And there are no payments since then.
No payment since then.
Did you check for a record in the United States or Canada for a driver's license?
Checked all 50 states and Canada. Checking for any driver's licenses for Richard Atwood and found none.
And did you check the local law enforcement report writing system?
We did. We checked Michigan State Police, checked local departments to see if there was any reports involving Richard Atwood and found none.
And these, does the Michigan State Police have an intelligence unit?
They do, sir.
Okay, why don't you explain a little bit to the jury what they do?
The Michigan State Police Intelligence Unit has a variety of databases available to them to assist in searching, in this particular case for individuals. Three of the most common databases that they would use are TLO, Accurate, and Clear. And each one of those databases would include things like utilities, addresses, phones, and found no record for Richard Atwood.
And in your experience as a police officer working with Michigan State Police and the Sheriff's Department, have you found that occasionally that intelligence unit will locate somebody that you cannot find?
Most often, they will.
I'm going to show you People's Proposed Exhibits 109 through 111. Ask you to look at these.
The first one, People's Proposed Exhibit 109, is correspondence from Equifax, one of the credit agencies, which indicated that
I just asked you first if you recognize those documents.
I do recognize them.
And what are they?
The first one being letter of correspondence from Equifax indicating that no record for Richard Lawrence Atwood. The second, People's Exhibit 110, is a letter of correspondence from TransUnion. Again, the same thing, no subject found for Richard Atwood. The third is from credit agency Experian, and for looking for records for Richard Atwood, and there were no records found.
Just for the sake of the jurors who may not owe anybody any money, what are these credit agencies? What do they do?
They'll keep the records of loans, any credit cards. They have, if you miss a payment, they'll definitely get it on there. So they'll track your financial history.
And again, there was no record from either of these three major reporting agencies, correct?
There was none.
Your Honor, move for the admission of 109, 110, and 111.
No objection.
Court would admit 109, 110, and 111.
Based on that record search and the facts of this case, was a petition drafted that was filed on August 15, 2016 to the Newaygo County Probate Court for a determination of death.
It was, sir.
And as part of that process was, there are hearing dates set.
There was.
And as part of the law regarding that process was that hearing date noticed out in a local newspaper.
It was.
I'll show you People's Proposed 112. You recognize that document?
I do.
And what is that document?
This is an affidavit of publication. The notification was put in the Times Indicator on the following dates. The first publication on March 3rd, 2017. Second publication on April 5th, 2017. Third publication on May 3rd, 2017. And the fourth publication of the hearing was on June 7th, 2017.
We already moved to the admission of 112.
No objection.
Court would admit 112.
And was a hearing held regarding determination of death for Richard Atwood?
It was.
And do you recall that date?
Not off the top of my head.
It says it. It's on the affidavit. That refreshes your memory on the left side.
The hearing date was to take place on July 18th, 2017, at 9 a.m. probate court before Judge Dimkoff.
And were you present at that hearing?
I was.
Okay. And at that hearing, did anybody appear in response to that affidavit to state that Richard Atwood is alive?
Nobody.
Were the facts of this case presented to the probate judge, not only in written form, but on the record?
It was, sir.
And was there an order that came out of that hearing?
There was.
Okay, I'm going to show you guns first. I'm going to show you People's Proposed 113. Ask you to look at that.
This is the order establishing death.
And what does that order state?
That there was a hearing given. The death of the decedent, Richard Lawrence Atwood, Date of birth 7/29/58, occurred on August 10th, 1983. Time of death impossible to ascertain. A death certificate will be issued. And it's signed by Judge Braden Dimcock.
And does it indicate on the lower right the seal of the probate court?
It does.
Your Honor, I move for the admission of Peoples 113.
No objection.
Court would admit 113.
If I could publish it to the jury, Your Honor.
You may.
And as part of that order by the probate judge, does it indicate that the state of Michigan shall issue a certificate of death?
It does.
And you recognize they look like this, sort of official and longer?
Yes, sir.
Okay. Show you People's proposed 114. Based on the strength of that probate judge's order, was a state of Michigan certificate of death certificate issued.
It was.
And is that document you're holding right now?
It is.
Okay. Does it indicate the name?
Richard Lawrence Atwood, date of birth July 29th, 1958.
And the date of death?
August 10th, 1983.
Your Honor, I move for the admission of 114.
No objection.
Court would admit 114.
Just a couple more questions. You indicated earlier that you became familiar over the course of really a couple decades with this case. Is that correct?
Correct, sir.
You're aware of all the physical evidence?
Ma'am.
You're aware of the scientific evidence?
Ma'am.
You're aware of the eyewitness evidence?
Yes.
Okay, and you've obviously been here for the trial, is that correct?
Correct, sir.
And again, we talked a little bit about some of the things that were reprocessed or new technologies. But again, how many people were re-interviewed in this case?
Approximately 120.
And in cold case investigations, do you get what I'm going to call anonymous tips?
We do.
Okay, and were those investigated in this case?
Each anonymous tip was looked at and evaluated with the witness statements as well as evidence.
And non-anonymous tips, were they investigated as well?
They were.
Somebody walks into your office and says X, Y, and Z. Did you look into that?
We did.
Okay. Did any other suspect line up with any of this evidence?
No, sir.
Another further.
Ms. Pardee or Ms. Smulders? Hi, how are you?
Morning.
All right, so hopefully no introductions are needed at this point here. We've been here for, I guess this is the third week. I wanted to get back to the probate matter that was opened in Newaygo County Probate Court. That was done by you directly or somebody else?
The order was drafted by the prosecutor's office. I testified at that hearing.
Okay, all right. And isn't it true that you do need somebody to be determined dead in order to prosecute against another individual in terms of a murder, for example?
I don't believe that's true, ma'am.
So you do not need to declare somebody dead before a prosecution against an individual for a murder?
I don't believe that's a requirement, no, ma'am,
You do not believe that was a requirement? Do you know that definitively, or you just based on your experience?
based on my experience.
Okay, all right. And then I know the death certificate was shared with the court and the cause of death indicated unknown. Why is it that it wasn't labeled or indicated as being a homicide at that point?
It's my understanding the purpose of that hearing was to determine whether he was dead, not the manner and cause of death. Only the medical examiner would make that determination.
And you need a body for a medical examiner to make that determination, correct?
Correct, ma'am.
Okay. I mean, can you say with 100% certainty that Richard or Ricky Atwood is in fact dead here today? Can you say that?
I can, ma'am, yes.
How can you say that without a body though?
With the physical evidence as well as the witness statements, the liver in particular being found in the trunk of the vehicle, that without immediate medical attention, would have caused the death of Richard Atwood. The admission to J.B. Martin as well as to Nolan Gant, that he killed him.
But you would agree that there's no direct evidence that it's all circumstantial, correct?
I would call the liver direct evidence, but as well as the amount of blood, the rest of it are witness statements.
Sure, which would be circumstantial, correct?
Correct.
So let's talk about the liver then. Are you aware of a report done by Dr. Gracier, and I believe I'm saying that name correct, back in '83? Was that part of your investigation to kind of go through all the old documents and reports?
It was.
Okay. And are you aware that that report said that that liver tissue was inconclusive, meaning he could not say it was human and that it could be indicative of animal tissue?
Correct. I think Dr. Cole also said that.
Correct. Okay. I know, and I don't believe it was brought up on specifically with you, but were you aware then going through the past history of the case about the handwriting samples?
I wasn't aware of it.
Okay. And I know at some point, and I don't know if it was directly from plaintiff's counsel or somebody testifying, but there was a period of time that was brought up upwards of 2 hours for Mr. Snell to give a sample. Do you recall that?
That would have been the Detective Miller's testimony, correct, ma'am?
Okay, all right. And are you aware of the circumstances that were involved during that 2-hour period?
Other than he was in the Kent County Jail, not aware of any other circumstances other than what was in the search warrant and what was relayed to me by Detective Miller.
Sure. And of course, you weren't there at the time, correct?
I was not.
Okay. And Detective Miller is not able to be cross-examined or testify, correct?
Correct, ma'am.
Are you aware that Mr. Snell was refusing to comply with that request?
I don't believe he refused. He gave the hands
Sure.
samples.
But during that 2-hour duration, it wasn't just 2 hours to give a sample, it was because of non-compliance. Are you aware of that?
That would be ma'am.
Okay. Has there been any other suspects identified by the department in this case?
No, ma'am.
Are you aware though, and I'm not sure if it was you or Detective Miller, that Walter Sanders was asked twice if he killed Ricky Atwood?
I believe I asked him that myself.
Okay.
When we look at an investigation, we either identify and or eliminate people. He would have been one of the last 2 people to be with Richard Atwood on that day.
Mm-hmm. And you asked him that, but yet he wasn't a suspect ever?
No, ma'am.
Okay. And the Gabriels, I know they were brought up several times. Were they ever suspects in this case?
They were not.
And a gentleman by the name of Richard Graves, was he ever investigated as being a suspect in this case?
We look at each individual name and compare it with the known witness statements as well as the evidence, blood, phone calls, and no, the only suspect that came up was Roy Snell.
Okay. And did you ever have the cigarette butts that were tested where they had a major and minor donor as well as the one that had a complete unknown donor? Did you ever have those tested against any of the other people that were willing to point the finger at Roy Snell in this case?
No samples were sent down. No buccal swabs were sent down for additional comparisons. Those samples would have been compared with the database with known DNA in the system.
Okay, so you didn't specifically have Walter Sanders or the Gabrion submit any samples?
I do know that Walter Sanders is in the system, and his DNA would come up. I can't say for certain Dave Gabrion's in the system, but I believe he is.
Okay, so when you say in the system, that doesn't mean you did a specific match against these individuals, correct? You just did a nationwide?
Correct.
Correct, okay. And then in terms of searching the 800 acres that's been referred to several times, you did infrared searches, I believe you did aerial searches, canine searches, and foot searches. And nothing has ever come up, correct?
No, ma'am, they weren't able to identify a location.
And how many times or what period of time, I guess, did these searches involve?
I do know that the 800, those were all done by Detective Sergeant Miller at the time. And in my conversations with him, those took place in 83, 84. So it happened over a period of time. Additional searches were done at other locations after that.
And I assume being through the police department and such, these are thorough searches, correct?
They try to be, yes, ma'am.
Sure. Have any other areas of land then been searched outside of the 800?
Yes, there is.
And nothing has come up?
They're not been able to look at a location on there.
And what other areas of land have been searched, do you know?
There was an area off of 1 mile, not far from Mr. Snell's residence, where it was reported that Mr. Snell Jr. was in that area, felt there was a swamp there, so we checked that area. We also did a canine cadaver search of Mr. Snell's property, a former property that's since been sold.
And nothing has come up in regards to any connection with Mr. Snell's properties?
No, ma'am.
Now, I had read something in the prelim by Detective Miller back in 2020, and I'm wondering if you could possibly shed light on this. When Detective Miller was contacting Roy Snell in the Kent County Jail in '85, he was given an affidavit. And I know a lot of questioning in the prelim and even with us here during this current case has asked Nolan Gant whether or not Roy Snell talked to him before or after talking with Detective Miller. I'm curious what this affidavit contains. Are you familiar with these affidavits that would be used? Okay, and what type of information would be on that?
That particular affidavit was, it indicated that Richard Atwood was missing, that the car was towed from the Gateway Motel, that there was blood in the vehicle, however, not a specific location of blood. There were phone calls made from that room, and the caller for the vehicle, I believe, I'd have to look at the search warrant to verify. I believe the caller of the vehicle used the name of Mike Roberts, calling for the tow of that vehicle.
So in summary, would it be fair to say that the key elements, or well, maybe not elements, but the key details of the case were contained in that affidavit?
I would disagree. The details that were in there, the blood, they were very vague. There was no indication of where that blood was. I would call them very vague. They were there showing their blood in the vehicle. However, it did not indicate that there was blood down the center console, into the backseat, and in the trunk of the vehicle.
Okay.
The information getting later on from Mr. Gant was very specific, and which was nowhere in that affidavit.
Well, would it be fair to say that if Roy had read that affidavit, he could have at least come back to the jail and reiterated what they were trying to accuse him of, meaning Detective Miller?
He could have told Mr. Gant where that blood was, yes.
Okay. Well, no, that's not what I'm saying. He could have told the details that were in the affidavit. I know you're saying that they're not details. I mean, to me, I would disagree, but the generalized details maybe versus the minute details, is that fair to make that comparison?
The general details.
Okay,
Yes,
yeah.
ma'am.
So would it be fair to say that that was contained in the affidavit, the generalized details?
Yes, ma'am.
Okay, and then he could have taken that information concerning the generalized details and went back to his jail cell and talked to Nolan Gant, correct?
He could have.
Okay. And that could be an explanation as to when you said the car was being towed, there's blood in the vehicle, there are phone calls. Those could all explain why Nolan Gant had some of those details wrong. He thought the engine blew up and that's why the car was towed, correct?
The details that were relayed to Mr. Gant were very detailed. They were nowhere in the search warrant. And the only way to know that is for Mr. Snell to have committed the murder.
But what exactly? Because I don't recall Mr. Gant talking about any sort of minute details that were correct.
But I would start with the blood. Mr. Gant indicated that Roy Snell said he shot him in the vehicle while Richard Atwood was seated in the front seat. This is consistent with the blood on the center console draining down and into the back seat. Mr. Snell told Mr. Gant that he then put him in the trunk of the vehicle. That is consistent with the blood evidence as well as the liver in the trunk of the vehicle. Those are very fine details that were not in that search warrant for the handwriting samples. He would have said that he would have buried the body, and in the trunk of the vehicle they find a broken shovel. The other thing, his statement, items that were not in the search warrant, because they were not known to Mr. Miller or Detective Miller at the time, is that he pulled out, according to Mr. Sanders, he pulled out a gun and wanted to rob Richard Atwood.
Oh, I'm not talking about Mr. Sanders.
Correct. But these are things that Nolan Gant testified to that correspond with what other witnesses have told us. So there are a number of details that were not in the search warrant.
But when Mr. Snell would be talking to Detective Miller, I would assume there is further explanation by Detective Miller, or if you were in that situation, to explain what is going on, correct? Or is there zero communication between the two?
There would be very little communication at that point because he was not being interviewed. He would have been told about what was in the affidavit.
Mm-hmm.
If he was interviewed then those conversations would have taken place.
But Detective Miller was there twice in 1985 at the Kent County Jail, correct?
He was, I believe, on February 20th the first time and February
Exactly.
28th the second time.
Okay. And I know you testified earlier that Nolan Gant was initially not cooperative when you first reached out to him, and that was in 2018, but prior to this investigative subpoena, correct?
I thought it was 2016, but when we done Tennessee Department of Corrections.
Well, I have a report from Wednesday, August 15th, 2018, that states he wasn't cooperative. Did you talk to him again before the investigative subpoena then, shortly before?
No, I would talk to him on the way up, bringing him up from Tennessee to Michigan for the investigative subpoena.
Okay.
The only time that I recall him being not wanting to talk to us was when we were in Tennessee.
Correct. This would have been, this says, and if I could read an excerpt. First of all, are you familiar with a report that it looks like it was investigated by both you and Ryan Mackey, dated Wednesday, August 15th, 2018?
That would have been during, we picked them up to the investigative subpoena.
Okay, well then maybe it was right before that then. But you had indicated that today that he wasn't cooperative, but in this report, it states that Gant stated he did not remember the conversation he had with Roy. That's a little bit different than uncooperative, correct?
It's not uncommon for,
Well, I'm not asking if it's uncommon, but it's different, correct?
Allow to answer the question.
So give him a chance to answer the question. And then just answer what she asks you. And don't give her any additional information until she asks the next question.
yes, ma'am.
You may go ahead. Ms.
Again, ma'am, please.
Sure. So not remembering a conversation is different than being uncooperative, correct?
I would disagree.
Okay. And isn't it true that he only remembered the conversation after being given his statement from 1985?
That is correct.
Do you know what happened to the vehicle, the Trans Am of Ricky Atwood?
It eventually was turned back over to the parents.
You know what happened after that?
I know they sold it.
And is that normal procedure to turn a vehicle over that is still an open case?
We would try to hold on to all evidence by today's standards. 1983. And I know it was parked at the Michigan State Police Post for an extended period of time before we could detect another. We would normally try to hang on to those items.
Okay. So maybe not normal procedure for today, but maybe back then.
Would have been.
Okay. If we had had it today, we could have examined the vehicle and we could have had further testing, and with new technology and new science, we could have been able to uncover possibly further DNA. Is that fair to say?
It's possible.
Okay. And were any fingerprints taken inside the vehicle?
And according to Detective Sergeant Miller's notes, yes, there was in the trunk.
And were those compared against anybody?
Yes, those latent prints were sent to the Michigan State Police Crime Lab. And I believe it was in 16, I called to see if those latent prints were of comparison value. And I believe it's record 15, if I'm not mistaken. It indicated they were not of comparison value.
So no matches.
Correct, ma'am.
And if we had had that vehicle today, we maybe been able to get better fingerprint testing, correct? It's possible.
It's possible.
And same thing for the shovel that was listed as an exhibit. Were any fingerprints taken on that?
We sent that down to the Michigan State Police Lab for DNA testing. As it's more conclusive. Unfortunately, there were multiple profiles, none of which they were able to do anything with at the Michigan State Police Crime Lab.
So no matches on that.
Correct, ma'am.
And no fingerprints taken on that then, just the DNA?
Correct, ma'am.
Okay. So I know some people have testified at length as to these alternative samples of DNA for Ricky Atwood. Are you aware through your research on this case then that there were 3 or 4 hospitals in the Western Michigan area that actually had direct samples of Ricky Atwood, but somehow those were lost or misplaced?
I'm aware of one, I believe it was from Holland, and there was a biopsy slide. However, it's my understanding from the Michigan State Police Crime Lab, it was not of usable value. And to the science of that, I can't tell you why.
Okay.
So that's still in evidence today.
But you don't recall reading anywhere where any of these samples were lost or misplaced? No. Now, I know with the hotel card that indicated Mike Roberts stayed at that Gateway Motel. You had indicated that the zip code was the zip code was affiliated with Cincinnati, Ohio, correct?
That is correct.
Okay. And you indicated that Roy Snell had lived there. But do you know what time frame Roy Snell had lived there?
I know he was, before he came to Michigan, so he'd have been younger.
Mm-hmm.
And then his mother continued to live there in Cincinnati.
So you don't know when Roy Snell had lived there?
It's my understanding from his history, he moved here when he was younger. He would go back to visit his mother,
Mm-hmm.
but he moved to the White Cloud area when he was young. I can't tell you what age.
Okay, so when he was younger, an adolescent at least, a minor,
I would think so. yeah.
correct? Well, would have to be right,
Yes, ma'am.
because in '83 he was 17 turning 18, correct?
It had been before that, yes, ma'am.
Correct, okay. And you don't know if he had lived there ever after that, meaning after 1983?
I believe he did stay in the Cincinnati area. It moved quite frequently, so I can't tell you for sure off the top of my head.
Okay, well, at least not in '83. We know not from '83 to '85, because in '85 he was in Kent County, correct?
Correct.
So it'd have to be some years later then.
Yes,
correct?
ma'am. That was
Okay.
much later.
Okay. Now, you indicated the other phone number that was called from that hotel, the Gateway Hotel, was from, and I missed the name, but a Mackey, correct? Was the last name?
No, Charles Brown was the registered owner of that phone.
But the mother of somebody, isn't the mother's name Mackey, or did I write that wrong?
And I believe her last name was actually Sharp.
Okay, sorry, I
No,
apologize.
I didn't testify to that. It was Roy Snell's girlfriend's mother stayed at that address.
Correct, so you don't know the mother's name.
Last name Sharp. I don't recall the first
Okay.
name off the top of my head.
And do you recall what the supposedly girlfriend's name is?
It's currently Cornelia Walson. At the time, it was Cornelia Mackey. She went by Neva Mackey.
Okay, that's where I got Mackey. All right, and did Cornelia live at that house?
I believe she did at one point, yes.
Okay, during the time period that we're talking about, 1983.
Or prior, yes.
Well, definitively, did she live there on August 10th, 1983?
No, I believe on August 10th, she had her own place.
Okay. And this was her mother's boyfriend, correct?
Correct.
And what was his name again?
Charles Brown.
And did you ever interview either three of these people? So Charles Brown, Ms. Sharp, or Camilla Mackey about this phone call?
Yes.
And what did they say?
Objection, hearsay.
Strike that.
Or would sustain the objection.
Did you find out any useful evidence from that inquiry?
Yes.
Okay, and can you explain to the court what that was?
Mr. Brown is now deceased, so he wasn't able to be interviewed. During Detectives Miller re-interview of Charles Brown and Ms. Sharp, and again, I
No, I'm
apologize.
asking you though. Did you talk to them?
I attempted to interview Ms. Sharp. She is on the beginning stages of dementia,
Okay.
so
And then did you talk to Cornelia?
Cornelia,
Sorry, I wrote that wrong.
yes, ma'am, we did.
Okay. And did she confirm she was the girlfriend of Roy Snell at that time?
She confirmed that Roy Snell was living with her for a period of time, yes.
for a period of time, but during August 10th, 1983.
Yes,
Okay. And did she indicate that Roy Snell was with her that evening on August 10th, 1983?
she did not.
Okay. Did she indicate that she was at the Gateway Motel on August 10th, 1983?
She said she was not.
She was not, correct?
Correct.
Are you aware of other people that have gone missing where a body never shows up, even in fact declared dead, but yet years later they reappear somehow? Maybe not through their own want, but have been discovered.
During the preliminary examination, I learned of one
Okay,
from Mr. Prysock. A Whitey, I can't remember the last name,
sure.
that went missing. I believe he was a fugitive, and he ended up showing up later on.
Mhm,
So that's the only one I'm aware of, simply because I looked it up
sure.
after Mr. Prysock asked me that question.
Okay. Are you aware of Lucy Johnson? She was missing for 52 years, purposely missing.
Your Honor,
for
can I have
52 years.
sidebar? for 1
Sure.
second? I'm sorry.
Sorry, Ms. Mulder's going to sign. We're going to take a morning recess now. So we'll stand in recess for about 15 minutes. What's that? Do my math, 20 after.
Not wanting to be found evading every sort of credit report bureau, passports, driver's licenses, etc. Are you familiar with that name?
I am not, ma'am.
Okay. How about Petra Polzitsky? She was missing in 86 and declared dead. I'm sorry, strike that, in 84 and declared dead in 89, and then was found in 2015. Are you familiar with her?
I am not, ma'am.
Okay. I know you indicated all the search techniques that you went through in order to try to locate Ricky Atwood. Again, you had the passport agency, credit agencies, loans, etc. But your testimony indicated that it was just United States and Canada, correct?
Those are the records we had access to, correct?
Okay. So you did not do a worldwide search, correct?
Not that I'm aware of, unless intelligence unit did one, and I'm not aware of it.
Okay.
No,
And more specifically, you then did not do Mexico, where you did not need a passport back in the day to cross the border. You didn't do any searches in
we
Mexico.
don't have any database for that, no, ma'am.
Okay. Going back to the call logs that were from the Gateway Motel, there were only 2 calls from that room 20, correct?
Yes, ma'am.
Okay, so one was to Roy Snell's parents' home, and then one was to this Gordon, Charles Brown's home, correct?
Correct, ma'am.
Okay. Now, I know the tow company, well, strike that. You were here when the tow people testified, Mr. Woody and Matt Zanton, I think is his name.
Zanto.
Zanto.
Yes, ma'am.
And they indicated that they got a call needing a tow, correct?
Correct.
Okay. Was a tow company ever on that call log from room 20?
Those call logs are only for long distance calls.
Okay. So there was no tow call company on that?
No, ma'am.
Okay. Was there a call then to Ricky Atwood's home on that call log.
The only two local numbers on that call log were Charles Brown and Roy Snell seniors.
You mean long distance numbers, right? Is it true that Ricky Atwood's home would have been a long distance call, correct?
It would have been.
Okay. And you were here for Nolan Gant's testimony, correct?
Yes, ma'am.
And do you remember when he said Roy had told him that he called Ricky and Ricky had came down to the hotel?
Yes, ma'am.
So that would have required a long distance call, correct?
If he called from the hotel, correct, yes, ma'am.
Okay, all right. Well, there weren't cell phones back in the day.
Correct.
All right. With all the people that you re-interviewed, did you ever promise them anything in exchange for their testimony?
Other than what was stated on the record from Mr. Nolan Gant, no, no, ma'am.
No one else, okay. I'm gonna just confer with co-counsel here real quick. Okay, we're on all second.
Thank you. Redirect.
Detective Rios, do you know the circumstances of any of these other missing persons cases that have been cited by the defense?
I do not.
And as part of your training and experience on these missing persons cases, strategies for trying to find
As far as
the body, so to speak.
you have to have an area to search, obviously. And then you would set up, if I was to conduct a particular search in a particular area, we would have several people online walking to clear an area. So that's how we do our foot search. As far as the cadaver search, cadaver dog search, when we used the cadaver dogs, they brought out multiple, I believe they had 3 cadaver dogs, and they were free searching because we didn't have a particular area. And again, they would do something very similar, clear an area and move over to another area, clear that area.
And again, we talked about some of the record searches you did too. Is that part of your training experience looking for a missing person?
It is.
And we heard testimony from Detective Miller, and I guess I ask you from you, when that Trans Am was found down in Grand Rapids, did this go from missing persons to a homicide?
It did.
Okay, and why is that?
Based on the blood evidence in the vehicle, the amount of blood evidence in the vehicle, and the would raise a lot of concerns. It would raise this from just a simple missing person to a homicide report.
And you can't compare that, obviously, because you said you didn't have any knowledge to these other missing person cases.
Correct.
The phone call back to the Snell residence. Again, I wanted to clarify, Snell Senior, one of those numbers that was called from Gateway Motel, long distance phone call back to the White Cloud area. Who was living at that home at the time?
Roy Snell Sr., Marilyn Snell, his wife, and Troy Snell. And I'm unsure if the younger brother Kelly Snell would have been there at the time or not.
And sort of splitting some hairs here, but about your interaction with Nolan Gant. But when you say he's uncooperative, when you go down to Tennessee, can you explain that a little more to the jury?
It's not unusual for somebody in the Department of Corrections not to want to talk to law enforcement, especially in the facility, because other inmates would see that they're talking to law enforcement, and they would have to go back to their cells and explain that why they're talking to law enforcement. So that would not be unusual for them to be not willing. However, when going over the statement with Mr. Gant, he indicated everything he told Detective Miller would have been the truth.
So what was his level of uncooperativeness?
That would have been it,
Maybe you say he didn't want to get involved.
pretty much. Yes, sir.
So he didn't go down there, he didn't cross his hands, he just refused to talk to you.
That's correct.
Okay. Now, we heard a question about Dr. Grazier's report. He was the Newaygo County medical examiner way back in the mid-'80s, indicating that he looked at the slides on the tissue on the spray bottle within the trunk. That's mouthful. Do you recall that?
I do.
Okay, and that report says liver cells.
It does.
And it indicates it could be animal or human.
Correct.
And when that slide was sent, those slides were sent to Dr. Cole, was he aware of that report?
He was.
And just to be crystal clear, then Dr. Cole is aware that that tissue, we heard him testify, but that tissue was a DNA match to Richard Atwood.
I believe he was aware of that, yes.
And testified to that, do you recall
Yes.
that? Okay. Dr. Grazier, there was no DNA in 1985, is that correct?
Correct.
And when Dr. Grazier authored that report, he was not privy to that information about the DNA match with Richard Atwood.
He was not.
All right, thank you.
Ms. Smulders.
Just one brief question. I know you just testified that it's not uncommon for people to not want to talk to law enforcement when you were referring to Nolan Gant, correct?
Correct.
But isn't it true that he actually wanted to talk to law enforcement in 1985, correct?
Correct.
And he actually independently, actively sought out Detective Miller and tried to make contact with him when he was incarcerated in 1985, correct?
That is correct.
Thank you.
No redirect.
Any questions from the jury? According to the testimony, people were, quote, standing in line to kill Rick Atwood. Were any other names given as to people who would want to kill him?
Other names came up during the course of the investigation. However, the witnesses, as well as the physical evidence, led us to only one person.
In interviews with Roy Snell, did he offer any other names of possible killers?
He offered additional information, people to talk to, yes.
Was there any evidence of a firearm discharge in Rick Atwood's Trans Am?
There was no indication in any lab reports or Detective Miller reports that they could show that.
In 1983, was the science there to test for gun residue?
I can tell you that the test is no longer used because it's not accurate. Whether it was used in 1983, I cannot tell you.
Do you know if there were any bullet holes found in the Trans Am?
I do not know of any. I'm sure that would have been something that the lab and the subsequent search by Detective Miller would have noted.
Any follow-up, Mr. Kowski?
No, Your Honor.
Ms. Smulders? No. Any other questions by the jury? May this witness be excused?
Yes, Your Honor.
Thank you, Mr. Detective Rios. You may step down. Take a brief sidebar with counsel, please.
questions or discuss? That's so.
Mr. Prosecutor, any other witnesses?
People rest, Your Honor.
All right. There's a couple of things I have to, it seems like you were just out, but I have to excuse you for a moment while I speak to counsel. So if you could take the jury out.
Not to take the stand at this time, and he is in agreement with our decision not to have him testify.
Mr. Snell, you've had an opportunity to talk to your attorneys regarding your right to testify or not to testify. Is that true?
Ain't nothing to testify to, I ain't do nothing.
All right. So you've had an opportunity to talk to them about it. Okay, that's a yes. You gave me a thumbs up. And it's you're in agreement with not testifying today. Is that right, Mr. Snell?
Not for me to testify for.
Ms. Smulders, Ms. Korndike, is it your intention to call any other witnesses for purposes of trial?
No, the defense rests, Your Honor.
All right. 11.
Couple things, Your Honor. One is the jury instructions. I did find one or two things that need to be changed. People are going to be requesting another jury instruction for second degree. I don't know if we need to have a discussion on record about those. The printouts should go to all of us so we can ensure that those are correct before closing a special.
Right. Okay, are you prepared? Go ahead, Ms. Korndike.
We're fine with the instruction with to include murder in second degree, Your Honor.
Is that 16? And we did have one, which we believe is not the correct wording on 16.4B.
There, what is the issue with 16? It's okay.
Court says.
It lists the offense as felony firearm, Your Honor. And we believe that it should be either larceny or robbery.
Larceny from a person for robbery. We would also need to, with the addition of murder 2, which we are drafting right now, we need the lesser included language as well. The lesser included instruction, we need to change the verdict form. We can do that in the next 10 minutes.
Larceny from a person or robbery.
Yes.
Right, and then murder second degree instruction, and then the lesser included instruction.
Yes. I can go back to my office quickly and draft those 3 and get them back to the court.
Verdict.
Verdict form have to be changed.
All right. And you think we should do those before you move into closing?
Yes.
All right. Ms. Korndike, any objection to that?
No objection, Your Honor.
Lesser included verdict form amendment the murder second. And then the changes to 16.4B, that clearly, if there's a typo, there was a typo too in 3.20. I think it should say the defendant is charged with 2 counts.
I just want to ensure that some courts now read them beforehand. My understanding from you is that you read after the
Yes.
closings. I just want to ensure that we
Sure.
are on the same page, reference them.
My intention would be for you to do your closings and then me to read them after closings, unless someone has an objection to that.
No, Your Honor.
No, Your Honor.
All right. With that being said, you still want to do, fix the instructions before we move into closings?
I guess with the time, yes, we'd like to do that because we're not going to do it until 1. We still need to bring out the jury to the defense arresting.
Ms. Smulders, Ms. Korndike, then what the prosecution is requesting is I bring out the jury, let them know that the defense has rest, break for lunch. They will amend that jury instruction. We'll come back after lunch, do prosecutor's closing, your closing, and then I would read the instructions. Any objection to that?
No, Your Honor.
Is that correctly clarified?
Yes.
All right.
Stand, the defense rests.
Okay, it's about 11:10. Of course, timing is always an issue here. There are some things we need to prepare for you before we proceed with the next step. So you're going to break for lunch now. Unfortunately, the courthouse is locked during the lunch period from 12 to 1, so it's difficult for me to resume before 1. So we will resume right at 1 o'clock into the next phase of the trial. I know that your lunch is coming in about the next 15 minutes, so we'll stand in recess until 1 o'clock.
Against assaulted or put in fear Richard Atwood. Second, that the defendant did so while he was in the course of committing a larceny, and a larceny is the taking and movement of someone else's property or money with the intent to take it away from the person. And then there's a definition of in the course of larceny. Third, that Richard Atwood was present while the defendant was in the course of committing the larceny. So the elements of felony murder: cause the death of Richard Atwood, intended to kill, cause great bodily harm, or create a high risk of death or great bodily harm to Atwood, and the defendant was committing or attempting to commit either a robbery or larceny from the person. And the elements of larceny from a person are: took his property without consent, was present during the larceny. Larceny is the taking or movement of another person's property or money with the intent to permanently keep it. The elements of robbery are: defendant used force or violence against Richard Atwood. Defendant committed a larceny while using such force or violence. And a larceny is the taking or movement of another person's property or money with intent to permanently deprive it. So we have killing of Atwood, plus the intent to do so, plus during the course of a larceny from the person or robbery. When you think of it that way, it's a little more simple. But again, you will be given these in writing, so you will be able to view those during your deliberations. Oh, sorry, it's present during the larceny. Second charge is felony firearm. And to prove this charge, the prosecutor must prove first that the defendant committed the murder, and second, at the time he committed the murder, that he knowingly carried or possessed a firearm. And there's some language about attempt, and a pistol is a firearm. And so before we start, and I'll go over those even more detail at the end, but what you have with felony firearms: committed or attempted to commit felony murder, got a firearm, and a pistol is a firearm. Now that you've all memorized that, and so when I speak to you, I'm going to talk about the evidence and how it informs those elements. And I'm going to frame all of my points about each element of the crime, highlighting that evidence. Your decision is to be based on the evidence, not argument or speculation. I know I keep saying that, okay, but it's one of the most important things that you have to think about as a juror. And again, I ask you, like one of the jury instructions says, to use your common sense as well. You have heard 21 witnesses and almost 100 exhibits have been admitted. That is the evidence you're to consider. And that evidence just demonstrates that the defendant is guilty beyond a reasonable doubt of all of the elements of felony murder and felony firearm. So let's talk about that. I guess I have to point this sort of that way. Okay, let's talk about Rick Atwood. We heard from his family members and his fiance. Rick Atwood was a 25-year-old man from the White Cloud area who was raised here by his parents, Gordon and Karen Atwood. He had 4 brothers and sisters, Annette, Gordy, Kurt, Lynn. He had a long-term girlfriend who became his fiance, Deb Kane. They lived together in a rented trailer in Croton. That testimony. Here we are today in White Cloud. No? Rick Atwood's address, Croton trailer. Again, they lived in that rented trailer in Croton together. He supported himself through dealing marijuana and also Deb's income from a job. Rick had a prized possession, and we've heard a lot about this car. Some of what I just said. It's the map. This, some people call it brown, some people call it maroon. A brown Trans Am. We heard this car referred to as his baby. He kept it clean, had work done on it with his friends, was proud of it. We specifically heard that he didn't let anybody smoke in it, and we also heard that Rick did not smoke. In fact, he wouldn't let anybody else drive this car, we heard a witness or two say. Rick sold marijuana to people in the White Cloud area. He dealt small amounts of marijuana to friends and acquaintances. They bought from Rick, and I think we heard some testimony, $10 or $15 at a time. Rick had a habit of keeping a roll of money in his pocket that he would pull out anytime he had to pay for something. And Deb Kane stated that this behavior made her nervous. However, we also learned that Rick, during his relationship, never had an unexplained absence in his life. One time, he passed out underneath a tree after a party, and a second time, he returned the following morning. Another time, he spent the weekend in Grand Rapids. Both were explained to Deb Kane. There's more pictures here of the Trans Am. We'll get more of those later. Okay, so let's talk about the timeline in this case. It's really fairly simple. Kane testified, Deb Kane, that her and Rick slept together in the trailer the night of August 9th, 1983, into the early morning hours of August 10th, 1983, like they had done time and time again. Deb testified that she woke up early in the morning with a plan to go shopping in Big Rapids with her sister. Rick's plan was to go to Grand Rapids to make a payment. Deb left sometime in the mid-morning, and Rick was still at the trailer. She traveled to her childhood home with her sister, got ready for the day, and drove through White Cloud. Sometime near noon, she saw Rick Atwood at the gas pumps in the southern part of town. Here, again, this is 30, the testimony, this is 37. This is Cross Street, sometimes called Main, but down 37. She waved to Rick as he was pumping gas next to the gas pumps. She never saw Rick Atwood again. Now, Rick Atwood met up with Roy Snell and Walter Sanders as noon approached. Walter Sanders testified that they smoked marijuana in the car. With those three driving around town, we then heard from Walter Philos. Walter Philos testified that he was driving his truck around town. And again, he's in this area, referred to as sort of the downtown area. It's not a big, it was a little bigger back then, we heard, but not a big town. He was driving his truck in town. He was friends with Rick Atwood. He had smoked marijuana with Rick and occasionally bought marijuana from him. He saw Rick in his Trans Am in town with Walter Sanders and Roy Snell in the car. There was discussion about meeting at the high school. Walter Philos grew up and continues to live in the White Cloud area. He knows by sight both Rick Atwood, Walter Sanders, and Roy Snell. Walter Philos testified that they met back within minutes at the high school. And the high school on the map is a little bit west of town. For those who don't know, we can talk about it. Just point it out again. So high school is parking lot right in front of it, right? There was a discussion between Philos and Rick Atwood, Walter Philos and Rick Atwood, about meeting later on. During that conversation between Philos and Atwood, Roy Snell and Walter Sanders were still in the car with Rick Atwood. Rick stated he had to take care of something and he would meet back with Walter Philos shortly. He watched Rick with Walter Sanders and Walter Sanders and the defendant drive back towards the center of town, testified back that way. He waited for a few minutes and then he drove back into town looking for Rick. He could not locate him nor the car. Walter Philos never saw Rick Atwood again. Walter Sanders testified that while Rick was using the payphones in the center of town, and again, here the center of town is here, cross street of Wilcox and 37. For those who are not familiar. And while Rick was outside the car using the payphones in the center of town, Roy Snell showed Walter Sanders a dark-colored handgun. Walter Sanders indicated, do you want to rob Ricky? When he showed him this gun. Sanders declined and indicated he better not do that. Walter Sanders had previously had a gun pulled on him before by Snell. Sanders testified he was dropped off in town and then Rick and Walter Sanders testified that he was dropped off somewhere in this area. Again, this sort of west of downtown area, 1 or 2 city blocks. Walter Sanders then said that he saw Rick driving and the defendant drive south towards Grand Rapids. Walter Sanders never saw Rick Atwood again. Deb testified that she returned in the mid-afternoon. She observed that there had been ashes in the ashtray and evidence that people had been over-socializing. Deb indicated that this was a common occurrence, not unusual. Missing from the home was Rick as well as the Trans Am. At first, nothing drew her suspicion as we're talking about the mid-afternoon. She knew Rick was going to go somewhere that day. However, she testified as the night progressed, she became more and more suspicious that Rick had not returned. It was highly unusual for him not to come home. She eventually became so concerned that she contacted Rick's parents. She has never seen or heard from Rick Atwood again. Now, before we get into the particulars of the criminal acts that caused Rick Atwood's death, I want to highlight the evidence that demonstrates beyond a reasonable doubt that he is in fact deceased. In particular, I'm going to speak about how there are no individuals who have ever given any testimony that they, in this trial, that they have seen Rick or heard from Rick or got a letter from Rick or an email from Rick, and that there is no record by Detective Rios's widespread search that Rick Atwood is alive. In fact, the family, some years later, even purchased a gravesite in Grant, memorializing their feelings about Rick. So again, Detective Rios testified he did a wide-ranging record search for any evidence that Rick Atwood is still alive. Detective Rios found that there were no records or any payments to the front of the court from August 1983 forward. There have been no passports issued to Rick Atwood, no driver's licenses in all 50 states and Canada. He checked all local law enforcement reporting forms, record reports, didn't find any record. Michigan State Police Intelligence Unit has some searches that they do to find missing people. No record there. checked all the 3 major credit unions, and there is no record of Richard Atwood. All of this was submitted to the evidence as well. Some of the evidence was submitted to the National Persons Database, and not a great slide to see, but you have that. And they have never reported finding Rick Atwood. So on the strength of the investigation by the police, and that's a copy, and you have it in the evidence. Anything I show you up here, you have in that collection, other than the slides that explain some of the law. That's the passport one. That's Equifax, TransUnion, and Experian, no record. So again, on the strength of that investigation by the police, a petition for a determination of death was filed in the Newaygo County Probate Court in 2017. A notice that this hearing was going to occur regarding the death of Richard Atwood was posted several times in the local newspaper. A hearing was held where the facts of this case were presented, and also the public or anyone was given an opportunity to show up and say, I know where Rick is. No one showed up for that. The facts were presented. And the Newaygo County, and it was, again, that's the affidavit to show that it was published in the paper. And this order was generated by the Newaygo County probate judge ordering an order establishing death on August 10th, 1983. And then that court ordered further orders for the issuance of a death certificate, an official death certificate from the state of Michigan, indicating Richard Atwood's date of death as August 10th, 1983. Now, having established that Rick Atwood is dead, and he has not been seen alive since August 10th, 1983, I want to point out that it's not really true that we haven't found Rick, all right? Rick was found, remains of Rick were found on August 11th, 1983 in that Trans Am. We heard testimony from John Vanderwoody and Rick Zanto that a car was towed from the Gateway Motel on August 11th, 1983 and brought back to their service station. We heard the car was dirty. We heard that the car was missing the dipstick and was out of gas, but was otherwise functional upon remedying those problems. We had a map of that as well. Those of you who are not as familiar with Grand Rapids. The location of the Gateway Motel on this is 28th Street. This is Grand Rapids here, southeast Grand Rapids. Gateway Motel here, East Beltline standard and towing service. Those are the relative locations. Again, we heard the car was dirty, it was missing a dipstick and out of gas, but it was otherwise functional. This Trans Am, Rick Atwood's Trans Am, is the scene of the crime. It was located and seized by Detective Miller after he put Detective Richard Miller, sometimes I'll call him Richard, sometimes I'll call him Dick Miller, testified that he had put the car into the law enforcement information network, and he was able to locate that Trans Am at the East Beltline service station in Grand Rapids, as I just said. And with the help of Glenn Moore, a trace evidence technician, that Trans Am was processed. And Detective Miller and Glenn Moore testified as to the condition of that Trans Am. And you can see from the exterior, it's dirty. And again, these are photos that you have in evidence. You'll be able to see actual printed photos. Sometimes they come out a little better than on the screen. That's the outside. And then we see the open air there. Testimony heard about that. Within the Rockford Post garage. Okay. However, as we showed you from the photos and also the testimony of Detective Miller and Glenmore, the condition of the inside of this car was particularly noteworthy. He testified to Detective Miller that there was a fine sand or dirt that looked like it had been smeared about the car, all over the car, for example. Or example here is the dirt on the inside there, all right? You heard testimony from Deb Kane that she saw the car shortly after it was seized by the state police. She was shocked by its condition. She had never seen it that way. And we also heard testimony from brothers and sisters that were shocked at the appearance of the car. Again, that this was Rick's baby. We would never have left it in this condition. Click through this again. Okay. Within this Trans Am, within Rick's Trans Am, were located some, what we started out as calling red-brown stains. Now, again, I'm going to pull these out. I ask you to look at these photos. I ask you to look at all the evidence, obviously, particularly on these photos, to look at the actual printed photos versus your memory of what's up here on the screen, right? See some of these photos of these, so to speak, red-brown stains. They're crevice. I ask you to look at those in particular, right? The marked red nature of those stains is pretty striking in the photos, even more so than we see up there. There was more blood located in the trunk. There was blood found in the air scoop and on a spray bottle seized from the trunk as well. And I would ask you to note, and we have it in evidence again, this broken shovel handle. And I ask that you note in these photos too, I have to move a little bit forward here. Again, here's some more of these. These photos are from the the driver's side, right side of the driver's side, next to the seat on the console. And as Moore said, gravity drawn towards the back seat into a sort of a pooling in the back. That is the back seat, that is the back of the driver's seat as you push it forward. This is a two-door. You had to, people remember the old two doors, you had to push it and climb in the back. Okay. Okay, the blood and the tissue and the items in the trunk. What I wanted to say before I moved on to this was, you note the fishing equipment in there, which Deb had indicated was also missing when he left. Right, there it was in there. Detective Miller also sees 7 cigarette butts, among other items from the interior of this car. He also noted that the stereo was removed. So numerous items were processed from this Trans Am, and I'd like to go over those one by one. First, I'm going to talk about these red-brown stains. Glenn Moore, who was a veteran at the time, he's since retired, of decades with the Michigan State Police, as a crime scene and trace evidence technician, processed this car along with Detective Miller. He referred to the blood in this car as evidence of a bloodletting event, and we'll talk about that a little later with Dr. Cole. He particularly noted that, and I said this before, but that the blood stains appeared to be gravity drawn from the side of the driver's seat back behind the driver's seat, sort of into the back of the car. And you've seen the photos of pooling basically in the back. The blood, again, he noted, was throughout the driver's side. And you will have his lab report to also match up where he actually took the samples from. Right? And another point I would like to emphasize too is that Glenn Moore had the foresight at the time to maintain several of these items and evidence in anticipation of future DNA testing. Blood was also located on this air scoop And you have the photos too, but I'm going to point out that's what we're looking at there. Because it can look a little bit on this photo like rust, but it was identified as blood. Using the technology at the time, Glenn Moore identified the stains on most of these objects as that of blood. And he also conducted blood typing on this blood, but we learned later that DNA has supplanted that technology. We don't do blood typing anymore. As he stated, and also as Catherine Meredith stated, it's a more, DNA is a more current and a much more accurate technique. Blood was also located on that spray bottle. I'll point to that because that's what we're talking about, this spray bottle right here. Don't touch the screen. The spray bottle. And again, you have the lab report, and I think that's the next. Here's some more photos of the air scoop. The interior, you can see the fishing equipment. That's his lab report, and you do have that in there. That way, it's easier for you to match, even though I will have some slides that show where the matches were too. But you can also look at that report. That's more of the report. All right, the DNA testing of this blood. The DNA analysis of this blood was performed by Joel Schultze and Catherine Meredith with the Michigan State Police Crime Lab Forensic Science Division. Both are highly trained forensic scientists with decades of experience in DNA analysis. They've been qualified as experts hundreds of times and testified in courts throughout Michigan hundreds of times, all right? Due to the age of this case being from 1983, and you heard from Detective Rios, also, investigators were unable to obtain a known source of DNA from Richard Atwood. And what we've learned throughout the course of this trial is if you want some DNA, you go to the person and swab their cheek with like a Q-tip. Sometimes you can get commonly worn items or something like that, all right? But when Detective Rios and others tried to obtain that, they could not, all right? We heard from Joel Schultze, all right, as to this technique, which is used frequently, as he stated, that if you obtain the DNA for the parents as well as the male siblings of an individual, that you can create what's known as an alternate, make sure we heard this, an alternate known source of DNA for Richard Atwood. And that was done in this case. Through this method, the division of the Forensic Science Division was able to provide this known source of DNA to be used for comparison against the DNA of the blood and tissue that was located in this car. Now, Catherine Meredith, she did the majority, the bulk of the testing, all right? And that you heard her testimony over quite a long period of time as to the method in which she obtains these results. And I wanted to point out where we've got the air scoop here, the blood stain from the air scoop, all right? And that's a match to Rick Atwood. And again, these are the probability numbers that it matches. These numbers are astronomical, beyond a reasonable doubt that these are matches. And she testified as to some of these numbers are frankly difficult to conceptualize. They are so large. We talked about 1 billion, 1 trillion, and the numbers actually, as we go forward in these, become even more, even higher, right? And so this is the bottom surface of the air scoop in the trunk. Match to Rick Atwood. And again, the population frequency data. Beyond a reasonable doubt, a match. We've got that location behind, in the pooling area behind the driver's side seat. Driver's side rear floor. Should have read that instead of making it up. And match to Rick Atwood. And again, the probability numbers here. Beyond a reasonable doubt, it's a match. And as the numbers get higher, trillion, quadrillion, under the driver's seat, blood stain. And it's important to note too that Glenmore identifies this as blood as well when they did the test, before they even take it to do the DNA. Match, Rick Atwood. And again, these probability numbers, beyond a reasonable doubt, this is a match. Talked about those numbers. Back of the driver's seat. Match, Rick Atwood. This blood matches Rick Atwood's DNA beyond a reasonable doubt. Again, these numbers, huge. All right. 7 cigarette butts were also seized from the Trans Am and tested by Captain Meredith from the lab. And you can see these cigarettes as well. I put a picture there, but you'll have these, you'll actually see them if you want to. They're all smoked down. They're clearly been smoked. You don't see any smokers anymore, but I think everybody knows what a smoked cigarette looks like. You recall that Rick did not smoke. You recall that Rick indicated that witnesses indicated that Rick would not allow anybody to smoke in his Trans Am, and I think those are important facts. 6 of the 7 cigarette butts that were seized from the Trans Am matched the defendant's DNA. And again, his DNA was obtained, the defendant's DNA, by means of the search warrant, which means judge orders a search authorized, and the police went and took a swab from the defendant. That DNA can then be compared to the DNA that was found on those cigarette butts. And 6 of them matches. And you have this report, that's why I'm not reading it word for word in your heard testimony. This is proof connecting the defendant to this car. Now we have what I call the DNA testing of blood and tissue on the spray bottle. And if you recall, just talked about it, but I want to emphasize it again. In the trunk, there is this spray bottle. By the air scoop. By spray, I mean, you know, like spray paint or something like that. There was some matter that looked like blood, globules, so to speak, that was found on that within the trunk. That's what we're talking about right now. There's a picture of it. And that tissue, globule, stain matched Rick Atwood. And this piece of evidence is especially important when it's paired with the testimony of Dr. Stephen Cole. And that's why I am going to talk about that next. Again, we have the match. You have that report as well, so you don't have to. You have the report from all of the reports. You have all the lab reports. There's that report. While it's fairly wordy, since you've heard the testimony, you can look over that again. It's fairly straightforward that there is a match. So Dr. Stephen Cole is the Kent County Medical Examiner, and he's a forensic pathologist who has over 40 years of experience. He's testified, believe he said in this court, but in many courts, 500 to 600 times throughout the state of Michigan. And what Dr. Cole was employed to do is look at slides from the tissue on that spray bottle, okay, to indicate that BPMs. Oh, sorry. So I want to make sure it wasn't my presentation. So he was employed to look at these slides to describe the tissue that was found in the trunk of the car on the spray bottle, right? And so some of this tissue was made into slides, and I think most people know what slides are, but when you think about a pathologist, you thinly slice some tissue material within the body, as he testified, put it on a slide, a piece of glass, you look at it in a microscope. That's what pathologists do all day, every day. And so he looked at these slides, and what did he say about these slides? First one he testified, this were skin cells. And then this one and this one, he said, were evidence of blood vessels, and this one particularly a broken blood vessel, all right? But most importantly, these final three slides, okay? This one, and this one, all right? Dr. Cole testified that he knew right away when he looked at them that they were liver cells, okay? He testified that the liver was a large organ that is asymmetrical on the body, favoring the right side, meaning that we have I believe a diagram of where the liver is, higher up in the body, and it moves down like this towards the right side. Dr. Cole indicated that individuals don't just shed liver cells as they're walking down the street. That these slides, again, here they are right here, and of course we have to rely on him. But I'm going to show them to you again so you remember which ones I'm talking about in particular. That these slides are indicative of coming from an individual who suffered a penetrating injury to the right side. He indicated most likely gunshot, and it was enough to free these small pieces from the rest of the liver and break blood cells, which is obviously not a normal occurrence. He testified that an injury of this type required immediate medical attention and that it would be life-threatening. And when Attorney Gunderson from the Attorney General's office inquired as whether this injury could come from a situation where the victim was sitting in the driver's seat. I don't know why I'm doing this while the podium is black. Sitting in the driver's seat from a gunshot from the passenger seat, he indicated that it could. Dr. Cole also indicated, and I think we got some questions from the jury on this, and again, I appreciate your questions, indicated that liver cells do contain DNA. He indicated with the DNA match to a human, which is what we have here, a match to Rick Atwood, that these could be identified as human origin other than animal, right? So these liver cells matched to Rick Atwood's DNA are evidence of his death by gunshot and being placed in the trunk. Again, the spray bottle in the trunk. Let's talk about the Gateway Motel. Trans Am was parked in the parking lot of the Gateway Motel on 28th Street in Grand Rapids when it was towed to the service station, as you heard from John Vanderwoody and Zanto, on August 11, 1983. Detective Miller and then also Detective Rios were able to find evidence that ties the defendant to the Gateway Motel on August 10, 1983, room 20. So let's talk about this registration card. Mike Roberts Jr. with the address, with the zip code. We see again, make of car, Trans Am, the date, checking in, the rate. We all wish $22 for a room, no more of that. Number and party, 2, room, upper right has the room as well. I know there's some other scribble on there, but I'd ask you to note that, room 20, okay, because that's important for the next exhibit. Okay, you remember J.B. Martin's statement about never leave your real name behind, right? But there's some other things about this that are important that we heard from today, I believe. Detective Rios determined that that is not a real address in Cleveland, Ohio. And he determined that that zip code is not the zip code for Cleveland, Ohio, but the zip code for Cincinnati, Ohio, where the defendant's mother lived and where he had lived for a period of time. I think I have some of those. But you have, I know you've been hearing about this card a lot. And look at the actual card in your jury. This is the actual checking card. This put up copies, but this is the actual seized by detective. Okay. Trans Am. Date. Okay. Gail Rushlow, who worked at the Gateway Motel in the 80s, testified about this long distance call log. Here it's a long distance telephone traffic sheet. But these long distance call logs were noted on a log in order to get payment from the people in the motel rooms back in the days when people didn't have cell phones, okay? Gail Rushlow also testified that there was no identification process for checking into a room in 1983. And for some of those on the jury who were a little bit younger, you didn't have to give your driver's license at a hotel to check in the 80s. There were more cash type businesses, and she testified that they would never check the person's identification when they checked in. That either the person checking her in or the person checking in would write that name down. So we have this long distance call log, and that was seized by Detective Miller. And we get 2 numbers out off of that. One number is to the household, the 689-6163, through a search warrant records and also verified by the 1983 phone book, which you have both of those things in evidence as well, to Charles Brown. Charles Brown was identified by Detective Rios, that address, as the home of the defendant's girlfriend's parents. And like that, 689-1786, a 10-minute phone conversation from room 20 on that date was to the defendant's father. And those are the pages, and you can look at those pages. It's just more evidence of the defendant's connection to this Trans Am, to this room, and to this murder. Let's talk about the defendant's statements. You're going to hear a jury instruction, all right? We talked about evidence, you're probably getting sick of me using that word over and over again. But the defendant's statements can be used as evidence against him. Let's first talk about, there's the jury instruction. It says you can, evidence of a statement can be evidence. Okay, let's talk about J.B. Martin. J.B. Martin grew up as essentially a brother to Roy Snell. The defendant and J.B. spent countless hours on the 800 acres, which he referred to as paradise, if you recall him saying. Hunting, fishing, dune buggies, snowmobiles. J.B. knew the whole family, but he spent most of his time with Roy. He lived 3 or 4 miles away, and they became close, camped overnight together. He heard some testimony that J.B. Martin had 14 siblings, probably needed a place to sleep. He stated that the Snells were like a second family to him. Roy Snell Jr. even called him Sonny. But it wasn't all positive for JB in this relationship. The defendant used to live in Cincinnati, and JB stated that Roy would talk about this time. The defendant would talk about his time in Cincinnati. And he recalls the statement that the defendant made: if you're going to rob someone, rob a drug dealer. No one calls the police. JB indicated he was told that when he was 15 years old, and it made him scared. JB also did know Rick Atwood, knew he had a Trans Am, and knew he sold marijuana. He had bought marijuana from him in small amounts several times. When he first found out about Rick missing, he didn't know who was responsible. When he first talked to Detective Miller, he had not talked to the defendant about this crime. But after Detective Miller made contact with JB Martin got a call from Roy Snell Sr., the defendant's father. We love you, Sonny, but you need to keep your mouth shut. JB indicated he felt scared, that he took that warning seriously. Most importantly, he remembers a chilling conversation that he had with the defendant in his own driveway in Broman. If you don't know where Broman is, it's just north of town, right? He testified that the defendant drove his Blazer over to JB's house, and they had a conversation in the car with the defendant in the driver's seat and JB in the passenger seat. And they had a conversation about Rick Atwood. The defendant said, you're pretty smart. You could put two and two together. Yeah, I did it. If I didn't do it, somebody else would. There was a long line of people. If people keep running their mouth, they're going to end up like Rick with their heads chopped off. And then he told this directly to JB Martin in the car. Then he asked JB if he wanted to go chop some wood. JB saw something in the back, like a body bag and a knife, and he was scared and was able to get himself out of that situation. He was terrified, and you heard him testify to that. JB Martin reached out then to Detective Miller back, and you have his written statement in here. Okay? Not a copy, you have the original, People 62. And he told Detective Miller what had happened and what had been said. Again, you have a copy of that. We've also heard that sometime later, the defendant reached out to JB on Facebook. And this was sometime after the cold case started to gain some steam. The defendant had not spoken to JB by JB's testimony in like 30 years. And he said that the defendant sort of asked him how he was doing, we love you, and that sort of thing. JB did not take that message well, and he thought it was odd that the defendant was now reaching out to him when he knew that that the whole case had been started to be investigated again. Because JB and the defendant were so close, we learned other information about him. The defendant told JB Martin that never to leave your real name anywhere. JB told Detective Miller about a trip to Grand Rapids where they registered in a Ramada Inn. The defendant or JB Martin and Roy Snell registered at the Ramada Inn on 28th Street, and that he had given a fake name then. With Detective Miller, JB was able to locate that registration card, which indicated JB Martin's name as well as the name of Bob Blast. JB Martin indicates that that is not a person named Bob Blast, but the defendant. This is, of course, identical to the method in which the defendant checked into the Gateway Motel on August 10, 1983. JB also testified that he had, on the 800 acres, had seen the defendant use guns, had a gun pointed at him before by the defendant, and knew he had access to a handgun, which he had seen him handle. Nolan Gant. Nolan Gant testified he was lodged in the Kent County Jail for a period of several weeks in 1985 with the defendant. The defendant and Gant struck up a friendship. They were staying in adjacent cells, but also spent time together at meals, recreation, that sort of thing. They got to know each other well. I will touch on this a little bit later, but the particularity of this admission to a crime by the defendant to Nolan Gant is truly striking. The admission aligns perfectly with the rest of the evidence in the case. And as Nolan Gant testified, from Chicago, doesn't know anybody else in this case. And we asked a few people such as J.B. Martin whether they knew Nolan Gant. Nolan Gant's from Chicago, now is in the Tennessee Department of Corrections. He doesn't know anybody else involved in this case, okay? The only way he could get these details were if they were given by the person who committed the crime, and that's Roy Snell. Gant stated they began by telling each other things that they had done in the past. He testified that this would come out piece by piece, little by little, as they got to know each other. Some things that Gant did, things that Roy said he did. And Nolan Gant told this information to Dick Miller in 1985. He described staying in the Kent County Jail, a 6'2" to 6'4", 200-pound African-American named Roy. And that Roy had told him that he had shot and killed a white guy, who took his money, drugs, and a car, and that the car was a Trans Am. Shot the victim. He indicated he shot the victim while he was in the driver's seat. That the driver, Atwood, had disrespected him and shot him first and in the side. And he said, "Motherfucker, you shot me." And then the defendant shot him again, some 5 or 6 times, as Gant states, to his death. He testified that Roy indicated that he put the victim in the trunk, that he buried the guy somewhere on private property, that he had buried the gun, that he had stayed in a motel in Grand Rapids, called a tow truck to tow the car. It happened in 1983, that he had used an alias, and that he had told him his dad knew about the murder. This was all told to Detective Miller in 1985. Now, we demonstrated to you through the testimony of Lieutenant Scott Nibeling, through the visitor's passes, that Roy Snell and Nolan Gant were lodged in the Kent County Jail together for several weeks in 1985, and that they stayed in adjacent cells, right? We also heard from the layout, we also heard about the layout of the jail and where individuals were able to speak to each other. I'm going to go to the simplified one. We're able to speak to each other in adjacent cells, and we heard testimony of them being we heard testimony, but also the visitors' logs, that they were in L4 and L5 for a period of time, demonstrated by numerous visitor logs, L4 and L5, and that you could speak to those individuals in adjacent cells, and also when you were out on recreation or meals. And again, Gant testified that this information would come out piece by piece as they got to know each other. And that again, Nolan Gant told this information to Dick Miller in 1985. And those, you have all those as well. They're a little bit easier to read than the scans. Those are all in evidence for you as well. Okay? So I want to touch quickly before I move on to the next topic on topic of witness credibility. Okay? Witness credibility is an important factor in any trial, right? And you have the full jury instruction up here. You'll get that full jury instruction. There have been some questions presented to witnesses that they've given different statements or have been uncooperative in the past, all right? And that's specifically the questions that have been aimed at Walter Sanders, J.B. Martin, and Nolan Gant. All right? And one thing before I keep going, how reasonable does the witness's testimony seem when you think about all of the other evidence in the case? And I ask you to think about that when you weigh these individuals' testimonies, okay? You should weigh these things, but I want to hit on a couple of other things, all right? All 3 of these individuals came in here and testified against an individual who they have information on about a murder, okay? I think you could tell, and it's your job to watch witnesses, the level of stress that this imparts on an individual, okay? They have to come in here and talk about something that they learned about a long time ago, okay? And in J.B. Martin's case, it's been threatened about, okay? And so what we have here is Walter Sanders testified, did not originally reveal his knowledge of this event because he was, by his own words, scared 20-year-old black kid in White Cloud, and he was afraid that they would implicate him in a disappearance that he had nothing to do with. J.B. Martin told Dick Miller everything he knew in 1984, and he's carried that burden with him ever since. He's endured threats and the passage of time with the weight of this information upon him. He testified that he was originally uncooperative with this information in 2016 because he told Adam Mercer he didn't want to get involved and didn't want to put his life at risk. That's how he felt after the threats. Nolan Gant also told what he knew in 1985, okay? The police, unfortunately, were not able to return to him for 30 years. When they finally made his way back to Tennessee, when he was in prison, he heard from Detective Rios, he didn't want to get involved, okay? The important thing is, with Gant, when he was put under oath at the investigative subpoena, and under oath at the preliminary examination, and under oath at this trial, he told you what he told Dick Miller in 1985. As Gant says, didn't add nothing, didn't take away nothing. All three of these men have some very important information about a murder, right? And for different reasons have avoided cooperating with law enforcement at different times. They have all testified as to those reasons, and now they have testified under oath. So about this handwriting sample. You will have also the original in evidence of this handwriting sample. Exemplar, it's called sample there, some people call it an exemplar. Detective Miller went to the Kent County Jail in 1985 in order to get a handwriting sample to potentially match the defendant's handwriting to that of the registration card at the Gateway Motel. Now, you've seen these now. Dick Miller testified the defendant took over 2 hours to fill these out. This was also the time when he was being questioned regarding this murder. The defendant stated to Dick Miller, somebody should tell J.B. Martin to shut his mouth. These forms were forwarded at the time to Bruce DeCracker, who was a handwriting analyst with the Michigan State Police. He's still a handwriting analyst in private practice. He reached the conclusion that the defendant was disguising, and that's the word that's used, disguising his handwriting during this exemplar. So we'll zoom in on that. Okay. In his 40-year career, he indicated this was one of the most clear-cut cases of disguised writing that he had ever seen. Now, the handwriting exemplar sheets were also forwarded to Lieutenant Detective Mark Goff, who currently works as a handwriting expert for the Michigan State Police. And again, both of these people were admitted as experts. They testified untold times in the state of Michigan. Detective Lieutenant Goff spent 24 hours, he indicated, over 2 weeks analyzing these documents. And I want to emphasize that because this is not just something where these two individuals just take a look at it quickly, okay? There's a method, you saw that method, all right? It's not just a gut reaction. There's a scientific method to doing this. An extensive analysis by Detective Goff also confirms his expert opinion that this was not normal natural writing, but that it was disguised writing. I will point out to you that when he was asked for this, he was being questioned, or he knew, because Detective Miller told him, the defendant knew, that this was about the murder of Rick Atwood. You have this report, and I talked about Goff. He's the other expert. So now I want to focus a little more on the specific jury instructions and touch on a few of them and concentrate on the elements and how the evidence proves the elements. Now, we talked about evidence being the basis of your decision. I've said that 100 times, but it's very important. When we discussed this evidence at length, the evidence here is a combination of direct evidence, like eyewitness testimony, scientific evidence, and circumstantial evidence. You should consider it all, but The jury instruction indicates that. Again, we have the sworn testimony, we know that's that. But it says you can consider all of the evidence. And this evidence demonstrates beyond a reasonable doubt that Roy Snell robbed Rick Atwood of his marijuana, his money, and his Trans Am by shooting him with a pistol while Atwood was in the driver's seat of that Trans Am. And while you've heard a lot of direct evidence and a lot of scientific evidence, I want to state about circumstantial evidence, all right? Because sometimes people think that means something bad, and it really doesn't. It really comes down to this. Circumstantial evidence is evidence that normally or reasonably leads to other facts. An example I would forward to you, and there are many in this case, but 6 smoked cigarettes with the defendant's DNA on it means that the defendant was in the car. You'll get a venue instruction, proven beyond a reasonable doubt that the crime occurred on or about August 10th, 1983 within the state of Michigan. Okay, the defendant's statements, again, can be used as evidence against the defendant, and we have 3 very strong ones. We have J.B. Martin, Nolan Gant, and also the statement made to Detective Miller, and also actually the statements made from Walter Sanders as well. Those should be considered by you as evidence. We did have 2 witnesses that we read the preliminary examination transcript, and you can take that evidence as if they were here in person. They were subject to cross-examination. That was Karen Atwood and Detective Dick Miller. Sometimes people read the crime books, watch the crime movies, talk about motive. It is not the prosecutor's duty, the prosecutor does not have to prove beyond a reasonable doubt why this crime was committed. I think greed is a pretty good answer there. You can take into account motive, but you do not have to. It was not one of the elements. So every crime is made up of parts called elements. And so the prosecutor must prove each element of a crime beyond a reasonable doubt, and I'm going to go over those elements with you. So we've talked about first degree felony. Let's do this one first, obviously. Okay. I've talked about how the evidence proved what happened. So what we have is a fact pattern where the defendant, robbed Rick Atwood of his marijuana, money, and Trans Am by shooting him with a pistol while Atwood was in the driver's seat of the Trans Am. And so that fact pattern, which is the evidence that's been presented to you and that we've proven beyond a reasonable doubt, now has to inform the elements. So we have first, we've shown beyond a reasonable doubt that the defendant caused the death of Richard Atwood. That is, that Richard Atwood died as a result of being shot by the defendant with a pistol. That's the first thing, that he killed him. Second, that the defendant had one of these 3 states of mind. He either intended to kill, or he intended to do great bodily harm to Richard Atwood, or he knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of his actions. It's pretty clear here with the violent nature of this death, there's clear intent to kill. And third, that when he did the act that caused the death of Richard Atwood, that the defendant was committing or attempting to commit the crime of larceny from the person or robbery. So we have the killing with the intent during the course of a larceny from the person or a robbery. So let's go over first larceny from the first person. First, that the defendant took someone else's property. The defendant took money, marijuana, and the Trans Am. Second, that he took it without consent. Here, clearly without consent, he was killed for it. Third, that the defendant moved the property. But it does not matter whether the defendant actually kept the property. The property was found at the Gateway Motel in the form of the Trans Am, having been separated from Rick Atwood. Fourth, that the defendant took the property from Richard Atwood's person or from his immediate presence. Immediate presence means that the property was physically connected to Richard Atwood or was right next to it. And again, Rick Atwood was in the Trans Am when the shooting occurred. Fifth, that at the time it was taken, the defendant intended to permanently deprive the owner of the property. The intent to deprive is clearly here as he killed him. Now, robbery, very similar, used force or violence against, assaulted, or put in fear Richard Atwood. He assaulted him by killing him. Second, that the defendant did so while in the course of committing a larceny. A larceny is the taking and movement of someone else's property or money with the intent to take it away from that person permanently. And in the course of larceny includes acts that occur in an attempt to commit the larceny or during the commission of the larceny or in flight after the commission of the larceny or in an attempt to retain possession of the property or money. Here, the murder and the taking of the property from Rick Atwood are nearly contemporaneous. They happen at the same time. He was killed and the property was taken from him at that moment. And again, the property is the money, marijuana, Trans Am, and its contents. Third, that Richard Atwood was present while the defendant was in the course of committing that larceny. He was present when killed in the Trans Am and the Trans Am money and marijuana stolen. Again, all of the evidence informs those elements. It's a little repetitive, but we've got the killing plus the intent to kill during the course of a robbery or larceny from the person. That's what I just said. Caused the death, plus intended to kill, plus during the course of a robbery or larceny from the person. We've proven that beyond a reasonable doubt. I went over all of these, and you will have them. You will have copies of this as well. Now, you're going to receive an instruction as well that talks about murder during the commission of a felony, okay? And this jury instruction is typically for a situation where the murder and the larceny or robbery are far apart in time. In this case, as I stated to you, the murder and the taking of the property are nearly contemporaneous, right at the same time. We don't have a complicated fact pattern in that regard. And so the second crime is felony firearm, okay? And I'm not going to read that, but you need to read it when you go back there. And essentially what felony firearm is that he committed a murder and that he had a gun, okay? It could be used for any felony, but in this case, we're talking about murder, okay? And that a pistol is a firearm. We've showed you that it was a pistol beyond a reasonable doubt. So I ask also that I will tell you that this as well has been proven beyond a reasonable doubt. So that's how the evidence informs the elements, all right? As you ask very specific questions as to what the elements are, and I ask you to read those and think about what I've said about how each element is met beyond a reasonable doubt. So J.B. Martin said that the defendant had a saying, never leave your real name anywhere. That's another way of saying cover your tracks. The defendant may have covered some of his tracks. He hid Rick Atwood's body, he hid the gun, but he didn't cover his tracks well enough. Witness by witness, exhibit by exhibit, question by question, the evidence is mounted against the defendant. The defendant last seen with Rick Atwood. Rick Atwood has never been seen since August 10th, 1983. There is absolutely no record of it. Walter Sanders indicated that the defendant showed him a gun on August 10th, 1983, and said, "You want to rob Ricky?" Walter Philos saw Snell and Sanders together the day Rick went missing at the same time as Walter Sanders. Walter Philos said that. August 10th, 1983, Gateway Motel registration card with a fake name on it. Fake address with his mother's zip code. Same Gateway Motel where Rick's Trans Am was towed from, August 11th. The call logs in the Gateway Motel back to the defendant's girlfriend, and the 10-minute phone conversation back to the defendant's father's address. Rick Atwood's blood in the car, around the driver's seat into the back of the car, matching his DNA, evidence of his violent death. Liver cells within the trunk of the car, matching Atwood's DNA, matching Gantt's statement. Evidence of a violent death and being stuffed in the trunk. 6 cigarette butts tested for DNA that match the DNA of the defendant, a car that Rick never let anyone smoke in. The defendant's admission to the crime to J.B. Martin, his close childhood friend, and the threats to J.B. The defendant's detailed admission to Nolan Gann at the Kent County Jail in 1985 details that Nolan Gann could never have learned of but anybody but the person who killed Rick Atwood. The disguised handwriting sample, which was obtained by Dick Miller, where the defendant indicated somebody better tell JB to keep his mouth shut. The list goes on and on and on, and you've heard it, and it's right there. Each piece of evidence leads back to Roy Snell. Pieces of evidence that are independent from one another, but all working together to be the body of evidence against the defendant. We ask that you find a verdict that is dictated by that evidence, guilty of first-degree felony murder and guilty of felony firearms. Thank you.
All right. The defense will have a chance to do closing as well, but I think it's probably a good time to take an afternoon short break so defense can get set up for their closing.
That happened, that you had to call operator about 2 weeks ago-ish. We were all sitting here and we were looking at PowerPoints. And they were from people's attorney, Mr. Rolston. And I'll have to admit, they look pretty good at the time. They seemed convincing at the time. But as Mr. Rolston said, and as Mr. Stay said today, that the words coming out of our mouths are not what you should be using or can use as far as evidence is concerned. Anything I say, plaintiff's counsel says, Ms. Horndike says, it's not evidence that can be used in making your determination. What only can be used is the testimony and the exhibits that were admitted for the trial. So then we start diving into the testimony and into the actual evidence. And it becomes clear that slowly but surely these PowerPoint slides, they become less and less credible and they start to unravel. And it's to the point where I don't believe you guys are left with much actual evidence that can be believable. I think the two things, looking at an outside perspective, I think the two things that are sticking points will be the DNA and the cigarette butts. But the DNA is, mind you, through a process of elimination to determine that it being Ricky Atwood's DNA. And there are several scenarios that could be a logical explanation for these two pieces of evidence. I don't think these two things alone also would even support a conviction where it's beyond a reasonable doubt that Roy Snell killed Ricky Atwood. Some of the scenarios that could happen for, let's say, the cigarette butts, for example. I know everybody that had testified had indicated that Ricky didn't smoke. Ricky didn't allow people to smoke in his car. But what if Roy Snell didn't know that? What if Ricky was, as one person testified to, at the phone booth, making calls, talking to people, and Roy Snell starts smoking in his car? What if, as Walter Sanders testified to, they went to the flowing wells, the mill pond? My understanding is back in the day, that's when people would go swimming. What if Ricky, again, was not in his car directly at that time, and the rule about no smoking wasn't common knowledge? Those are just some of the scenarios. For DNA, I know people have testified that Ricky was an avid hunter. The tissue, time and time again, through reports and through scientists have stated that the tissue that was found it cannot be determined whether it was human or animal. I know there's blood spatter and that through the process of elimination had been determined to be Ricky's. But again, if he's hunting, if he's cutting wood like somebody testified to, he could have hurt himself. He could have bled. And one of the scientists that testified also stated you can't timestamp the blood. So if there's blood in the front seat, back seat, or side, doesn't mean that all three of them occurred at the same time period. It's inconclusive. You can't determine that. These are just certain scenarios. I'm just throwing them out there because they're possibilities and they just don't prove beyond beyond a reasonable doubt, again, what the prosecution is trying to prove. So I want to kind of quickly, not quickly, I'll say briefly, I'm not going to go into too much detail because you guys were here, you guys heard everybody testifying. But I want to go through some of the key witnesses here. So first we had Deborah King. She was, if you recall, the girlfriend of Rick Atwood during the time period. I think the major points that we get from her is that the weather that day, it was raining. That is contradicting some other testimony from some other individuals who claim that they know Roy Snell killed Rick Atwood. But we also had a weather report for that day too, saying it was nearly a half an inch of rain that day. There's no reason to not believe Deborah King. She also indicated that Ricky was going to Grand Rapids that day to pay somebody money that he owed. So that indicates to me that, you know, it's not necessarily a friendly transaction if he doesn't ever show up. That person that he owed money to never called, never came by, never asked, hey, where's my money? And at this point, through testimony, we're thinking it's probably a couple $1,000s. And I don't think it'd be reasonable to believe that if you were owed money, you just would never follow through on that. Another thing that Deborah Kane had stated was that the Wright brothers were, which are these two brothers, were there around 2 o'clock. That is relevant because of the timeline. If you recall, the people that had testified and seen Roy Snell with Ricky, that was around noon that day. And when Ricky never showed back up again to meet his friend Walter Philos at the high school, it did start raining that day. So a common, reasonable scenario would be that Ricky went home after dropping off Roy and Walter. Another thing that is relevant or significant, I think, are that when Deborah came home, she saw some steaks in the fridge. Why that is relevant is because those weren't there when she left that morning. And the Wright brothers told Ricky that they were going to pay him the money they owe him in steaks. And it looks like they had to have come back in order to do that. Also, what's relevant is the ashes, the cigarette ashes, and the messiness of the actual trailer in which they were living. I think that's relevant because, again, it goes back to the timeline. Deborah Kane said she saw Ricky earlier that morning. Does it make sense that he had a bunch of people over shortly after she left at 8, 9 in the morning, partied, had beers, smoked? Or does it make sense that maybe after he got himself together, maybe after he went into town and then came back, he met with the Wright brothers, he got the steaks, they started drinking, they started smoking, etc. Next, we go to Gordon Atwood Jr., who then is the brother of Ricky Atwood. He testified saying that Ricky was paranoid. And he also testified that Ricky had ripped somebody off in Grand Rapids. A couple people that he mentioned that were people that were a red flag to him, if you will, were the Gabrions and J.B. Martin. He also mentioned that Roy Snell had money. He remembered seeing money on Roy shortly after Ricky disappeared. I want to point that out only because a lot of people have testified and said Roy had money. His family had money. They had dune buggies. They had fishing equipment. They had dirt bikes. They had four-wheelers. They had everything that anyone would want. In fact, I think it was J.B. Martin that said it was paradise over there. So I don't believe that it's uncommon or unreasonable for Roy to have money on him. He was never without. In fact, J.B. Martin also said he went over to Roy's because they had all of these things. He never said that it was a situation where they were starving for money or they were trying to do their best to make ends meet day by day. So I think those are the significant things that I want you guys to really think about in terms of determining whether or not there is evidence beyond a reasonable doubt and taking everybody's testimony into consideration. The next thing we have here are the tow guys. I'm just lumping them together. Of course, you guys, you've heard testimony from each. But in a nutshell, what we got from that is that there are multiple employees at that facility. And so it comes a chain of custody issue, people inside and outside the car, people sitting in the vehicle, people driving the vehicle. But I think which is really, really significant from all of this is that absolutely no one saw any fresh blood anywhere in the vehicle or outside the vehicle. We had testimony of blood being near the driver's seat, the steering wheel, in the trunk of the car, outside the trunk of the car, on the dash of the car, and no one out of all these employees, and I think there was up to 10 employees, saw blood anywhere. Now, keep in mind, prosecution wants you to believe that this event happened the night before. So less than 24 hours, it's not even less than 12 hours beforehand. So the fact that nobody saw anything, it's a huge gap in their story. Another thing that I think is significant from the tow guy's testimony is the fact that this vehicle sat outside 2 months unsecured. You heard testimony that it was in a parking lot, that at that time they did not believe there was a gate or any sort of security around the parking lot. So that allows anybody to be able to come in and tamper with any evidence. And tamper, I don't want you to think that I'm saying it intentionally, but to be able to go in and out and not preserve this vehicle and not preserve any evidence that would be in the vehicle. So that is, the significant factors with the tow guys. Next, we have Walter Sanders. He really was inconsistent throughout everything. The weather he thought was sunny. He was adamant that it was sunny. He was adamant that Roy sat in the back seat and that he sat in the front seat this day. And I'm using air quotes with this day because in the end, we don't even know what day it is that he's talking about. He couldn't remember the color of the gun, but rather than not saying I don't remember, he would say it was blue or it was black. He also couldn't remember where he was dropped off at. And again, not saying he couldn't remember, he was consistent with the story that it was the dentist. But when records indicated that there was no evidence, there was no records from the office that he ever went to the dentist that day, he then said the game room. He also then was inconsistent when he said that Roy had told him during that day to rob Rick, or that let's rob Rick together, or something to that effect. But in 1983, he never said that. And then in 2004, he claimed he said it, but he was only 85 to 90% sure, which again, red flag. I'm not sure how you can be 85 to 90% sure. It's either you heard it or you didn't hear it. But then in 2016, he says 100%, yes, that's what Roy told me. And in 2020, and what, last week or the week before, he's sticking to his story. Also, he talked about a confession. He, in 1983, again, says nothing about a confession to any police or any detectives. And then in 2016, he says, yes, but he's not 100% sure if Roy confessed. 2020, he said he didn't confess. In 2022, he said he did not confess. These are huge details when you're talking about a murder case that you cannot ignore. Like how does one forget if somebody confessed a murder to you? How does one forget if somebody asked you to rob at gunpoint a friend of yours? It just doesn't make sense. He did testify that he did not like Roy. I think that's pretty significant if you're trying to point your finger at somebody. But I thought also, which was pretty striking, is at the beginning of the preliminary examination in 2020, he, before even being questioned, he was adamant in saying, you're not gonna find a body, you guys better stop looking, we're not gonna find a body. And to me, again, huge red flag. How does he know that? Why is he so convinced that you're not going to find a body? I think he probably knows a little more than he's leaning on. Another thing noteworthy is that he did indicate that Ricky was a big time drug dealer, and that leaves for another handful of possible scenarios as what could have happened to Ricky. Some other inconsistencies were with his testimony were where he was even picked up at. In 2016, he maintained it was at this grocery store, and he went into great detail about the location of this grocery store, the streets that this grocery store was on. And then all of a sudden in 2020, and just last week or the week before, he stuck with, he was picked up at the mill pond. He used some very interesting language, I think, when he was talking about and testifying about who he saw at the high school that day with Rick Atwood. He had maintained throughout all his previous testimony and statements to the police and detectives, as he did just last week, that it was Dave Gabrion, when in fact Walter Philos came and testified indicating that it was him who was at the high school. The words that he used, though, were so selective. He said that he assumed it was Dave Gabrion and that he thought it was Dave Gabrion. And I think he said those words because that was different than any other previous testimony, because he knew it wasn't now. And the reason why he knew it wasn't is because at the 2020 prelim examination, it's just like it is now today. It was right after COVID times and things had to be live streamed through YouTube. Not only live streamed, but you can watch it days after the fact. So that's my guess is he realized he was wrong in this lie and is trying to correct it. Another thing completely inconsistent, but rather significant, is that where he actually said he was dropped off here at one point, but where he may or may not have attended with Ricky and Roy, and that is called Flowing Wells. In 2016, he remembers going to the Flowing Wells, and even in 2016, he says Roy was dropped off first, and it was Ricky and him that went to the Flowing Wells. But yet in 2022, he had zero recollection of ever going to the Flowing Wells whatsoever. So Walter Sanders has some major inconsistencies. The admission he claims of Roy, or the confession, who was dropped off first, the weather, the dentist office versus the game room, Dave Gabrion. And if you guys recall the end of his testimony, he actually could not remember what month it even was that he was talking about. So maybe some of these things occurred and he's piecing together some truths and some lies, but in the end, he had no idea if he was even talking about August 10th, 1983. Walter Philos, the only reason why I put him in here is because it really supports the inconsistencies of Walter Sanders, and also supports what Deborah Kane had stated earlier, and that is that the weather was raining on August 10th, 1983. The inconsistencies that he did point out, though, were that Roy was in the front seat, not Walter, and Walter Sanders was in the back seat. He also stated, and I think it's kind of significant because it goes to a number of scenarios that could happen because we don't know exactly what happened that day. But he did say that Rick did not like driving in the rain. And so, that being said, like I stated earlier, it's very possible that Rick went and dropped off Walter Sanders and Roy Snell and went back to his house because he was driving that Trans Am and it was starting to rain, like Walter Philos had stated. Then we have J.B. Marvin. He has some inconsistencies as well, and some things that not even inconsistency, but that is just, it's impossible to wrap your head around. First of all, he talks about this badass Trans Am statement that some girl made in Grand Rapids when he was down there in November of 1983. Yet when he was talked to by the police in March, so let's say 4 months later, March 1984, he did not include this statement whatsoever. He also testified and stated that he didn't even know Ricky was missing in November of 1983. And that's why it didn't cause any sort of alarm bells to go off in his mind. But that I can't wrap my head around. It's a small town, maybe a little bit bigger back then than it is now. But yet this was big news around the town and he didn't know. It doesn't make any sense. It's not reasonable. And, you know, it shatters the rest of his testimony in my mind. He also talks about this conversation that he had with Roy Snell Sr. And again, he verbatim told the testimony in his statement. However, there are explanations to it. It wasn't that outright threat. It is possible that Roy Snell Sr. heard rumors, and some of those rumors could have been that J.D. Martin is trying to point his finger at his own son. And doesn't mean or doesn't equate to the fact that Roy Snell Jr. is guilty of this act. All it means is he doesn't want J.D. Martin to point his finger at Roy Snell Jr. I mean, that's just one of a million other reasons. It did not say that I am going to hurt you. You are telling truth. You are, you know, it doesn't go into detail. It's just a vague statement that, yes, J.D. Martin testified, saying was threatening to him, but it starts out with saying, we love you. And so that is not conclusive of an admission of guilt or anything like that. J.D. Martin then talks about this confession that happened from Roy Snell sometime between March of 1984 and October in 1984. But yet then you fast forward to 2016, and I know prosecution wants you to believe that people sometimes become uncooperative, but I don't think uncooperative is the right term. These people are downright saying they don't remember. And what more plausible for not remembering is if you lied about it 20 years prior, 30 years prior. That makes more sense to me. But J.D. Martin didn't remember any sort of confession from Roy Snell in 2016. And then again, he was talked to in October in 2016. And not only did he say he didn't remember, but he said Roy actually never confessed to it. And then in 2018, when he had that investigative subpoena, he didn't want to admit it at first, but then in the end, he did say that Roy confessed. Then at the prelim, he also said Roy confessed, and of course in 2022, he's sticking to his story. But when questioned about why his testimony and why his recollection of the events wavered, he tried to just say he didn't like the two detectives at that time. So not only the first one, Detective Mercer, who interviewed him, but then for whatever reason, he also didn't like the second one that interviewed him months later. To me, I don't think that is just not being cooperative. I think that is because he actually didn't remember the lies that he was saying. And he's trying to cover up more lies with more lies. Because again, just like Walter Sanders, how do you not remember if somebody confessed or not? And not only not remember, how are you adamant now in October of 2016 saying he, in fact, Roy Snell never made a confession to me? What J.D. Martin did highlight, I think, is another thing, is that he had some possible other people that may have been involved. He did think that at one point the Gabrians were involved. He also thought that Rich Graves was involved. And he also thought this group of Ford men called the Bank Group were involved. And then another thing that I thought was notable that J.D. Martin said is that he said that Ricky didn't have friends, that Ricky had enemies, and that he thought it was possibly just a bad drug deal happening. After JB, then we had Nolan Gant. Nolan Gant has a very selective memory, and he only remembers things in which he receives a direct benefit from it. In 1985, he was the one that actively pursued Detective Miller to tell him about the case, to tell him about some confession that Roy Snell had told him. But he only did this, and he admitted to it, in order to help him with his own case that was involving him and his brother. Then when that didn't work out, in 2016, when he was re-interviewed, he says he does not remember because he didn't receive any benefit from it at the time. And again, in 2018, he didn't get a benefit from testifying or having any sort of recollection, so he just said that he didn't remember. And again, when something that you had tried to tell a detective 20, 30, 40 years ago, if you don't remember, it's probably because you've done lies on top of lies. And the only time he remembers is when he reads his statement from 1985. And that's what happened in 2020 at the prelim examination, where he was given, and I read some of the actual transcript from it out loud, because he was given this piece of paper they kept on referring to. And in part of that transcript, it was noted that someone had read to him, and what he stated on that stand, word for word, what was in his previous statement. And that's the only way he remembers. Because again, how hard would it be to remember a whole event that is full of lies that you had stated in 1985 if it wasn't reduced to written form to help you remember what you stated? The other thing that I think that is significant is this before versus after question, because you heard me talk to Detective Rios this morning, and Roy Snell was met with Detective Miller twice in February of 1985. One time he was given an affidavit that had some key points from the investigation. And another time he was talked to by Detective Miller, again, about the same investigation and the same key points. Roy Snell was able to take that piece of paper with him back to his cell. And so again, in 1985, Nolan Gant says that he heard this confession, if you will, from Roy after he met with Detective Miller. And then in 2020, he then changes the story, and he was saying bits and pieces was only after, but the majority of it was before. And then again, last week, he said it was before. And in seeing the YouTube videos of the preliminary examination, I think will let you discover why that was so significant, because in the testimony, it did state that Detective Miller was so adamant about asking, was it before or after, because he wanted to know if Roy Snell had this piece of paper with him with all the key elements of the investigation when he went back to his cell. I think this also explains why Nolan Gant was able to testify to some of the major or the bigger details, but got a lot of the minor things wrong. That, for example, he knew that there was the Trans Am, he knew about the 100 acres, and he knew about a tow of the Trans Am. But the minor things, not only are they wrong, it's just there is no evidence of it whatsoever. I believe Nolan Gant kind of came up with some scenarios and filled in the gaps to make it a full story from beginning to end. He indicated that there was a hotel room that Roy Snell had reserved with his girlfriend. He indicated that he called Ricky down to Grand Rapids because he knew Ricky lived way up in White Cloud. He indicated that the money amount that Roy Snell stole from Ricky was $30,000, and I think at one point $35,000, and at one point $37,000. He also, since he knew about the tow, he just then filled in the gaps again, saying that the engine blew up. I want to really highlight that because if you are familiar with an affidavit and you're familiar with the elements of a case, it's really easy to draw those big elements out and then try to tell a detective for your own benefit what someone may have confessed to you, even if it's not true. The other thing that I really want to highlight, and I know I stated it earlier, but it's this independent memory versus assisted memory. One of the last questions that I asked Nolan Gant was if he ever had an independent memory of this event aside from 1985. And with resistance, I believe he did indicate that he didn't, because I walked through each year of the times that he either testified or talked to detectives. And not only in 2016, but 2018 and 2020, all of those transcripts indicated he didn't remember and had to either read or have somebody read this piece of paper to him. So I just don't think that any of this testimony can be credible. He only remembered when he got a benefit from it. And even from last week, he's going to get a letter from the Attorney General of the state of Michigan, a letter of cooperation in hopes that that will reduce his term or his sentence, or at his next parole hearing that he will be able to get out. Gail Rushlow, I believe her. I believe she doesn't remember a thing. She also did not remember swearing, raising her right hand under oath in 2020. But I think that was pretty consistent in 1983. I think what would be notable from that is that she did have a plain view of the parking lot, a plain view of the room from her vantage point at the lobby, if she honestly was even working that day, because her testimony was all over the place. But she said back in 1983, if she said that then that would be truthful. But either way, she didn't see anything. She didn't see a car, she didn't see Roy, she didn't see Ricky, she didn't see nobody. But what we can get from her testimony, which I think is important, are two things. The process in which to make a long distance call from a hotel room. It was common knowledge, she testified to, that back during those times, everybody was aware that that is the process that had to happen, that you had to call an operator, and when the operator would ask you what room number, you give them the room number, and then they monitor the actual phone call, they monitor the actual duration of the call, and then they provide that information back to the hotel itself. I think it seems really odd if you know this procedure that you're just going to call places that just highlight the fact of you are who prosecution wants to believe or claim that you are. It doesn't make sense to me. There are a number of reasons why anyone would call Roy Snell Sr.'s house or would call this other guy Gordon's house. We don't need to know all the reasons, but what we need to know is that it doesn't make sense to take a yellow highlighter basically and highlight the fact that you're calling these people when you know it's going to come back to you. I don't care what age you are, if you know that procedure, you're not going to do it. You're going to go down the street, you're going to go to a payphone, and you're going to make a call. Another thing that I want to point out with that as well, and just briefly, is that if Nolan Gant was telling the truth, then there would be a long distance call to Rick Atwood's home as well. There would be that extra call, because remember, Nolan Gant has stated that Roy Snell had called Ricky to come down to Grand Rapids, and that's when this supposed event occurred. Another thing the last thing that doesn't seem reasonable to me is that if it was Roy, he not only made these calls then to places that would just have a relationship with them, but then he would also go back the very next day, pay his long distance bill upon checkout. I mean, if you think about it, it just doesn't seem rational. If he went and he killed Rick Atwood that night, And he did this with the body all the way up in Croton again, and the car's a wreck. And, you know, my guess is this is taking hours, if not being up all night. And then the very next morning, you're going to be responsible enough to go back to the lobby of the hotel and pay your long distance bill before you check out. It just doesn't make sense to me. Now I'm lumping the DNA evidence all together. I think we had 2 or 3 different people testify for the DNA, but the things that I think are notable are that over and over again, it was testified that human tissue is similar to animal tissue. In one of the first reports that was made, the doctor is no longer alive, but he actually said that his report was inconclusive on this liver tissue. Didn't make the same conclusions that the people that testified last week did. His was flat out inconclusive because he was stating there's no way to tell the difference. Also, another thing that I think is important is that one of the doctors used the word suggestive and said that it was suggestive of liver tissue, meaning the sample that he had, he said there's really nothing else that it could be. We're talking about a murder case here, and something being suggestive of liver tissue is a really big point that we can't ignore. I think another really big point is that there was no other tissue found. So if we're trying to wrap our heads and believe that Ricky Atwood was shot and somehow this liver tissue came out, but no other tissue came out, no other particles of clothing came out, and the sample itself was so tiny, as the doctor had testified to, it doesn't lead me to believe, it's not conclusive, I should say rather, that Ricky Atwood died in that vehicle. It's just, there's some gaps in these scientific methods, and it doesn't show beyond a reasonable doubt that this event occurred. Another thing that I think is notable is that I believe all 3 of the people that testified regarding the DNA stated that you can't determine the age of the samples. This is kind of what I stated earlier. If you have blood in the front seat, in the back seat, in the trunk, doesn't mean that all 3 occurred at the same time. It could be years apart because it was all dry. I believe the only thing that was testified to is in order to determine an age or get a reasonable conclusion of the age would to be if it was fresh versus not fresh. And so again, we cannot determine that these samples of blood all came from the same time period. The cigarette butts kind of floor my mind. I understand about these major and minor and these unknown donor samples. I get that. But the fact that there was one cigarette that was 100% of an unknown donor, no major, no minor, nothing like that, and yet it wasn't tested at all with anybody else's DNA. I don't understand why not. I know Detective Rios has stated that there were no other suspects in the case, but there were a list of people that were interested people. And I believe having a cigarette with 100% unknown donor is a huge alarm to me. And I'd be curious, honestly, if that 100% unknown donor was tested against Walter Sanders. Another thing to note is environmental factors and how that can decay. And it wasn't very conclusive of whether or not a major and minor donor could have been a minor and major donor, meaning the minor could have been a major donor at one point, but because of environmental factors, it could have switched. And we do recall where the car was stored for at least upwards of 2 months at the tow station. So there are a lot of environmental factors that have been at play there. The last thing with the DNA is I know Attorney Stay had indicated earlier today in his closing that where these samples of blood stains came from. But I want to highlight the fact that those places or those areas in the vehicle were only told to these scientists. They were only given the written information of where these samples were taken from, where the cigarette butts were taken from. There are some chain of custody issues that come into play, and they got it from somebody who got it from somebody who got it from somebody, because we're talking about a case now back in 1983. So it's not conclusive that these cigarette butts honestly even came from the vehicle. It's not conclusive that the actual samples of blood that were tested came from the vehicle. With the handwriting analysis, I think there's a few things that I want to highlight here. First of all, one of the people that testified regarding handwriting, one of the two, indicated that it is not an exact science. Again, when you're pinpointing or trying to pinpoint a murder on somebody, we kind of want an exact science. We want beyond a reasonable doubt that it is Roy Snell. Another person, the last person that testified regarding the handwriting, the last thing he stated when Ms. Korndike asked him is that he could not say with 100% certainty that that handwriting was Roy Snell. I have down here saying third time's a charm, because if you remember, he needed one time a sample from Roy Snell. Second time, it was the first time was inconclusive. He needed a second sample from Roy Snell. That was inconclusive. And then he needed a third sample from Roy Snell. And that's when he concluded it was Roy Snell's. But then again, remember, not with 100% certainty. So he used the words, it could have been written by Roy Snell. And then with the 2 hours of being quote unquote uncooperative, that is the 2 hours of handwriting samples. Again, there's many scenarios that can happen. We were not there. We do not know what was taking place. Roy could have had to sit down, had been read other things. He could have said he's going to refuse to cooperate. He's going to refuse to give samples. We don't have a time frame of that. We do not have a recording of that. We cannot definitively say that it was him taking pen on paper or pencil on paper for 2 full hours. The last person that testified was Detective Rios. He testified to opening probate and in order to get a death certificate. And on that death certificate, it clearly stated the cause of death was unknown. And he also testified to this thorough search of the 800 acres. Sorry, can't go back. Sorry, this is my first time using PowerPoint too, by the way. So it's a little out of line. I won't hit the button anymore. So he testified that the death certificate was unknown. He also testified that he did a thorough search. Not only him, but people in the past have done thorough search of the 800 acres. If we're trying to believe Nolan Gant, if we're trying to believe J.B. Martin, if we're trying to believe all these people that testified, they would find something then on these 800 acres. We have now 39 years that you can still look and search. They used infrared technology, they used aerial technology, they used dogs, and no one found nothing. I also then, like I stated previously, wanted to highlight the affidavit when I questioned Detective Rios about that, and the 2 meetings that he had in February with Roy Snell at the jail and how that could correlate to what Nolan Gant may have or may not have testified to. Again, like I stated earlier, there was no long distance call to Ricky on the hotel call log. Again, that would comport with Nolan Gant's testimony if what Nolan Gant was saying was true. Then we have no vehicle. I asked Detective Rios what happened to that vehicle. It was released to the parents, is what he stated. But having that vehicle here today, I think would shed a lot of light on this present situation. We're trying to go against evidence that was collected 39 years ago. There's no way we can cross-examine that evidence. We can only take what the police have found and not do any sort of independent research on our own. Detective Rios also stated there are no other suspects despite evidence against that. I think that the fact that there are some key players that testified and everybody pointing their finger at Roy Snell, despite the inconsistencies and the contradictions of their testimony, is key, and I'm not sure why no one looked further into those people. He also testified that he did not request any other testing of DNA. Again, not sure why. We have 2 cigarettes that have a major and minor, one being Roy, the minor being we don't know, and then 1 cigarette having a complete 100% unknown donor. He also testified to the fact that he read a report from 1983 where there was a definitive conclusion, no definitive conclusion rather, of human tissue. And that's that liver tissue sample that I've been talking about. And that it could very well be animal tissue, which again correlates because Ricky was a hunter. I think the jury asked a really great question, that there's no gun residue or bullet shells in the vehicle. If the prosecution's theory is correct, you would think that there would be some sort of residue from guns. You'd see some shell casings, maybe a hole in the vehicle. Again, like I stated earlier, if it's a gunshot, there should be some sort of fragments of clothing, maybe other tissue found. Absolutely nothing, but just little microscopic piece of liver that could be animal in the trunk of the car. And lastly, the fact that there is no body. I mean, again, we're talking about a murder case here, and having none of these things that I just mentioned are huge and cannot support beyond a reasonable doubt. So in sum, and I promise this is the last slide here, the circumstantial evidence that we have is who was last with Ricky. Heard Walter Sanders say that, but yet we heard Walter Sanders say a lot of other things, including that they dropped they dropped Roy, and Ricky and Walter went to the flowing pubs. We have the hotel cards with the handwriting. Again, that person testified that they cannot definitively say with 100% certainty that that was Roy Snell's handwriting. We have the weather inconsistencies. Walter Sanders trying to point the finger at Roy, saying it was a beautiful sunny day, when in fact it was raining that day. We have J.B. Martin saying that Roy confessed, and then later saying, no, he didn't confess, or I don't remember. We had J.B. Martin saying that the story about the badass Trans Am in only 3 months after August 10th, 1983, but yet fails to include any of that information when he had to have known in March of 1984 that Ricky was missing at that point because he was being investigated on that. We have Walter Philos saying that Roy Snell was in the front seat that day and Walter Sanders was in the back seat. We have Sanders' entire testimony that is, again, all over the place, and all you can do at best is just eliminate that all from the equation because he's up and down and left and right. But I think what is especially important is him pointing the finger at Roy Snell being the last person with Ricky that day. We can't believe him. We can't even believe where he got picked up that day. So how can we believe that he's saying the truth when he's trying to point the finger at Roy Snell saying he was the last person with Ricky? We got Nolan Gant's testimony when all he would testify to are times when he would receive something in return. Other than that, he had no memory, no recollection because everything was made up from the very beginning. We got the statements that indicate that Ricky was a big time drug dealer. He owed people money in Grand Rapids. I mean, there's a million other different scenarios that can take place as to what actually happened to Ricky. Then we got the DNA evidence and the cigarette butts and how those are not only chain of custody issues, but having other donors and can be inconclusive of human versus animal tissue. Then we got that big wad of money that Nolan Gant was saying. But then we have all the other people's testimony talking about it was $2,000, $3,000, maybe $1,000. I think his mom, which was read into testimony, said it was just a wad of hundreds, so under 1,000. But when we correlate that to JD Martin's testimony of everything that they had on that property, again, dune buggies, dirt bikes, four-wheelers, the Snell family wasn't without. There's no motive as to why Roy Snell would rob Ricky for a couple $1,000s and some weed when he had all of that and more at his home already. With the last two things that we have go together, we have the cause of death being unknown. It's not listed as homicide. We also have no body. That's all the circumstantial evidence that I see that plays a significant role in this. And as far as direct evidence, we have nothing, absolutely nothing. Nothing was preserved, nothing was saved. We can't go on any of that other than people's testimony that have been on the stand testifying and admitting that they said one thing one year, the very opposite thing the next year. So in sum, today we are asking that you look at all of this. You really dive deep into everything and everybody's testimony and ask reasonably, what is the conclusion? And we ask that you return the verdict that the only reasonable verdict is that Roy Snell is not guilty on all counts. Thank you.
Thank you, Ms. Smulders. Rebuttal? I think we need, just Jamie, can you help them do that?
Bill.
Thanks, Judge.
Bill.
Yes, sir.
Staggered.
Yeah, thanks. Okay, thank you. Now, you guys have been here since, 3 weeks almost, and taking in the case as we move along. There's no doubt that each of you individually has made a sacrifice. And to that end, thank you very much. Now, I told you at the beginning of this case, when jurors universally that I've spoken with after jury trial have always remarked that what a positive experience it was to go through the process. And, even though it took time out of their day, took them away from their families, took them away from work, all of you made the sacrifice and decided, yeah, I'll sit. And I hope that you all have that feeling, okay? Now, if I'm sitting where you are right now, I'm probably asking the question, how long is Ralston going to talk for? And, I'm going to talk, I'll be as quick as I can, as efficient as I can, but, what Ms. Smulders said is very true. It's a homicide case, okay? And, Ricky's family, it's important to them. It's been important to them for 39 years, okay? And the idea that we want to rush something so that we can get to 5 o'clock, I just can't do it. Not even gonna try. Okay, so, take your shoes off, make yourself comfortable. I'm going to talk for a little bit. I'll try to get you out of here by 5, okay? But it's important enough, I'm going to beg your patience. I'm going to ask for your patience when I go through some remarks here, okay? Okay, yeah, I've been using PowerPoint since 2004, okay? And these are not evidence, okay? In fact, I'm going to point out some of the things Ms. Smulders had in hers were mistakes at best, okay? And we'll get to that in a moment here. But let me try to summarize here the last 50 minutes of Ms. Smulders' remarks on behalf of her client, Roy Snell, okay? And it goes something like this. Walter Sanders is a liar. J.D. Martin is a liar. Nolan Gant is a liar. The evidence can't be trusted because, as she puts it, there's chain and custody issues, but she never really drills down and tells you, hey, on behalf of my client, this is where I think the evidence is lacking. It's things like, there's a million reasons, there's a million other reasons of how it could happen, or I can't wrap my mind around it. Or to me, it seems like this is what would be reasonable. That is not the test in this case, okay? I mean, those things that she says on behalf of Mr. Snell are not the test in this case. The test in this case is beyond a reasonable doubt, okay? And the court's going to instruct you very clearly on that a reasonable doubt is just that. It's a doubt that's based on reason and common sense. It's not a possible or imaginary doubt. It's not some imaginary doubt. but it's a doubt that you can point to and say, this is reasonable to your fellow jurors and say, this is why I have a reasonable doubt. And for instance, if your fellow juror said to you, you know, I don't think Roy Snell killed Mr. Atwood. I think somebody from outer space came down and did it. You would say to your fellow juror, okay, you've given me a reason, but it's not a reasonable reason. It's not one that's based on reason and common sense. Okay? So that's the test of any criminal case, whether it's assault and battery or first-degree murder. Okay? It's proof beyond a reasonable doubt. And what I would suggest to you, that much of the argument that was just given to you over the last 50 minutes was an attempt to inflate the burden. Well, I mean, it's not 100% certainty. Well, guess what? I mean, we went through this in voir dire in great pain, okay? Because we all agree that if it was 100% certainty, you'd never be able to hold somebody criminally responsible. Because at the end of the day, how many things in our life are we 100% certain of? Let alone a homicide, even if the homicide happened last year or the year before. I mean, you're not going to come in and have 100% certainty. And so what that is, that's an attempt to inflate the burden of proof. Now, each of you to a person promised that you wouldn't let me or Mr. Stay or Mr. Gunderson whittle that away, make it a smaller burden. And you all promised that you wouldn't let anybody inflate it, okay? Because that would be unfair to victims of crime, okay? I mean, the people of the state of Michigan, that's who I represent, okay? And I take that job very seriously, but it is the burden of proof I'm held to is consistent, okay? At the start of the case and at the end of the case. It's proof beyond a reasonable doubt, nothing more, nothing less, okay? So anyways, the argument that's been offered up to you on behalf of Mr. Snell is, well, it's just a big misunderstanding, okay? That really what happened, Mr. Snell is the victim of a series of individuals who are willing to lie and tell untruths about him, individuals who are unrelated and unconnected. I'm going to get to that a little bit more when I go through my presentation here. But suffice it to say that no, these individuals had victimized Roy Snell. No, Roy Snell victimized Ricky Atwood when he shot him 4 or 5 or 6 times in his Trans Am back in 1983. That's the victimization in this case that we're talking about, okay? The idea that when she talks about chain of custody issues and the evidence and, we don't know where everything was. No, every time that we asked Judge Dykeman, we moved to admit exhibit number 1 through 109 or 10 or wherever we left off the end was. That whole point in getting that to you, move to admit, no objection. The item is admitted into evidence. In other words, it has cleared chain and custody issues. And that's why you get it as exhibits during the course of the trial, okay? I mean, that's how we prove our case, okay? So to suggest that anything that was admitted during the course of the trial lacks proper chain and custody is without merit, okay? The basic theory that was offered to you by Ms. Smolders is what we call the brick in the wall theory, okay? There is a wall made of bricks and mortar. The individual bricks are the individual pieces of evidence that form the wall, okay? And what Ms. Smolders wants you to do on behalf of her client, Roy Snell, who killed Ricky Atwood in 1983, is, you know what, let's take this one brick out of the wall, we're gonna look at it, we're gonna say, can't trust that brick, we're gonna set it aside. And we're not gonna consider all the bricks in the wall at the same time. She asks you to suspend your reason and common sense when she takes one piece of evidence, says, you can't believe J.B. Martin, it rained 0.46 inches of rain on that day. Well, you know what, there's plenty of days in July and August when thunderstorms come to Michigan and it gets warm in the afternoon and the big clouds build up, and anybody who's been around long enough knows that, yeah, we get thunderstorms in the state of Michigan in July and August. Some of them are quite powerful. Now, 0.46 inches of rain to anybody who, is a farmer or pays attention or has a rain gauge on their fence post out back, knows that you can get 0.46 inches of rain in a single event in an hour or two in the afternoon. And what she's trying to do is she's trying to say, see, you can't believe Walter Sanders. Remember what we said during voir dire. You're going to get the instructions from Judge Dyken. Not every fact and circumstance has to be proven beyond a reasonable doubt. That's a classic example of what I'm talking about is, oh my gosh, a weather report from Dick Miller says it rained 0.46 inches of rain. So Walter Sanders must be lying to you. No, maybe it rained that afternoon, and maybe that morning when he was walking around the mill pond, it was a nice morning. And, and just by way of example, Walter Philos, he doesn't have a big dog in this fight, okay? He's the guy that, saw Rick Atwood and Roy Snell riding around that Trans Am together, and they met up at the high school, okay? And yeah, I admit, Walter Sanders, not the most sophisticated person in the world, okay? Probably not the most educated, but he knew what he knew, okay? And he says, yeah, it was sunny that morning. I remember that. And, he thought he saw Dave Gabrion up at the high school, and he made a mistake, okay? Not every fact and circumstance has to be proven beyond a reasonable doubt. Only the elements of the crimes charged, okay? And Walter Philos says, yeah, I saw Ricky Atwood in his Trans Am and Roy Snell in the front seat. I don't have to prove who's in the front seat, who's in the back seat. It's not an element of the crime. And Walter Sanders in the back seat, okay? And here's exactly what Walter Philos' testimony was when he was cross-examined by Miss Smolders, who was trying to get him to say, was it raining? Was it raining? No, he says, it was getting ready to rain. It was going to start raining, was his testimony. And one thing that I know about jurors is when you put 12 people in the box, 15 right now, and you try a case, nothing gets missed. Juror number 1 may not pick up what juror number 7 does, and juror number 10 may see something juror number 8 didn't. But at the end of the day, I know that you'll come back with that analysis. So Walter Philos said, no, it was getting ready to start raining. It hadn't started raining yet when he saw Walter Sanders, Roy Snell, and Ricky Atwood in the Trans Am. Not every fact and circumstance has to be proven. That's exactly what they're trying to do with their closing argument, trying to increase the burden of proof, okay? That's not fair to victims of crime, and you wouldn't let me whittle it away because that wouldn't be fair to Mr. Snell. Hold us to that standard. Proof beyond a reasonable. Part of their explanation is, there's animal. It's all animal DNA, or it's the liver is from some animal that Ricky killed. First of all, it is very clear to anybody paying attention. Ricky Atwood loved Michigan. Okay, he loved to hunt. He loved to fish. I'm going to show you a little bit of that in a minute. But at the end of the day, he had 2 vehicles. Remember, he's a 25-year-old guy. He's got that TA. He's got it dialed up. He's got the new rims on. You look at the pictures. He's got it pretty looking sharp. Okay. And you heard Deb Kane tell you he had a work truck. He had a truck that he chopped wood with. Okay. And anybody who hunts and fishes knows that a 25-year-old guy, if he's going to go out and he's going to go deer hunting or even small game hunting, he's not taking his Firebird Trans Am. He's taking the truck. Okay, so to suggest that, Ricky took the Trans Am when he went out deer hunting last year and threw the deer in the trunk doesn't make sense. It doesn't ring true. It doesn't ring with your life experience. Okay, so to suggest, and remember, the globule, part of their theory too is, oh, you know what? Dick Miller got it wrong. Scott Rios got it wrong. The prosecution team got it wrong. Oh, I know. Lieutenant Goff, the handwriting expert, got it wrong. DeCracker got it wrong. Everybody that touched the case, it's just a big misunderstanding on behalf of Mr. Snell, is their explanation. Okay, and that doesn't make sense because that fits in with the brick in the wall theory. Each individual brick, oh, this one doesn't look good, it's not reliable. Got to set that one aside. But when you get done, you got all the bricks stacked up, it's still a wall. Okay, so what they're asking you to do is suspend your common sense of how you look at something. For instance, when you look at this map, and it's Nuevo County with all the, here we go, this is a better one, with the 24 plus townships plus Grand, Nuevo, Hesperia. Okay, when you look at Nuevo County, do you just look at Ensley Township? Well, no, when you look at the map in Nuevo County, I mean, you look at the whole map. You don't look at one individual block of it. I mean, and to suggest that that's how you do it, and then you take Ensley aside, okay, you can't think about that anymore. And then, okay, we'll look at Grant, we'll think about Grant. No, we're gonna take that aside. Don't think about those two together that we just took apart. No, you look at the whole picture. That's what we do in life, and that's common sense. Let's talk a little bit about the rules of the road again. Only the elements charged, the crimes charged must be proven beyond a reasonable doubt, not every fact and circumstance. Evidence is sworn testimony from the witness stand and exhibits and anything else that Judge Dykeman tells you to consider as evidence. Motive is not an element, but it can be considered by you in determining guilt. The motive in this crime is the oldest motive known to man. It's greed. Testimony that is corroborated by other evidence is more reliable. Okay, that is the jury instruction that Judge Dykeman is going to give to you. And the testimony of Richard Miller and Karen Atwood are to be judged as any other witness. Okay, I mean, the reason that's the case, and the reason the judge is going to give you that instruction, is because there are times in litigation, in court cases, where a witness dies or becomes unavailable. And when that happens, okay, their testimony through good people like our court reporter is preserved. Okay, and they have the right to cross-examine them at the earlier hearing. That's a requirement before you can get it, is there has to be the ability to cross-examine and test the witness. And if that witness becomes unavailable between that hearing and the next one, you get to get it. Okay, and there's nothing wrong with that. There's nothing underhanded about it. I mean, it's part of the court process, and the system that we have makes sure that you get reliable information. Okay. Okay. Let's just kind of start with Dick Miller's testimony. Okay, and I know none of you met him or know him, but but he's asked the question back at the preliminary examination. Why did you focus on him being Roy Snell? And Dick just summed it up as perfectly as anything. All the evidence went directly to him. There were no other indicators that somebody else was involved in a homicide. Every telephone call or activity, statements to other people, think Nolan Gant, think J.B. Martin, they all came back to his doorstep. He was responsible for the murder. Okay, Miller's testimony from the preliminary examination, I asked you to consider that. Okay, the question is Ricky Atwood dead? Okay, I want to go back to 1983. Because in 1983, I was about 25 miles to the east here going to Ferris State College. Okay, before they made it a university. And 1983 was a little different than 2022 today. Okay, and in two different principal ways. Number one, we didn't have the communication that we have today. Cell phones, email, everything that we do to communicate is so much faster today than it was back in 1983. Number two, our mobility back in 1983 was not nearly like it was or like it is today. Okay, I mean, just think of this. In terms of the proliferation of flying on an airplane. and how you can get to different places, how our airports are today compared to what they were like in 1983. I mean, they're much more sophisticated, My point is 1983 was a different time. Ricky Atwood was living in a trailer out in Croton, okay? He liked to fish and he liked to hunt, okay? And he was born and raised in Michigan. He didn't go to Mexico. He didn't go to Peru. He didn't go to South America. He didn't flee to Europe. I mean, this was a young man of simple means, okay? Yeah, he sold some weed on the side and, did what he did, and him and Deb Kane were going to make a go of it, okay? Matter of fact, and pay attention to the details. Just got a new dog, just got a new puppy. Remember that? That was testimony from Deb King. He just got a new puppy. He wasn't taking off and going anywhere. I mean, there was some comment by Miss Smolders on behalf of her client, Mr. Snell, that, Detective Rios didn't look in Mexico for him. Well, he didn't look in Russia for him either. And the reason he didn't is because Ricky Atwood is dead. Okay, as hard as that is for the Atwood family to finally accept. I mean, at the end of the day, Ricky Atwood didn't jump on a spaceship and go to the moon. Okay, I mean, he was a simple guy that barely got out of Newaygo County. I mean, the big thing that Deb Kane talked about was, he went down to Grand Rapids once on a planned trip, told me he was going to be down there for a day or two working on the car. And then number two was the time that he got too drunk and he fell asleep and he came home. Okay, I mean, those are the only two unexplained absences. And you heard the testimony from his siblings and his mother's testimony. Karen was read to you. This was not a young man with great means who could get on a plane and make himself disappear. And remember, it was 1983, it wasn't 2022. Okay, so, we look at, he's not been seen by family or friends in 39 years. There's no evidence of his existence in the Michigan Secretary of State, the United States Department of State, any of the law enforcement agencies within the U.S. And we've already been through what the Michigan Intelligence Operations Center did trying to find him. Ricky Atwood is deceased. Death certificate issued by the court. You've got to convince a judge you get a death certificate that someone's dead, and that is what happened in this case. The grave marker the family bought, and he vanished on August 10th, 1983, because Roy Snell killed him that day and buried his body somewhere. Maybe up in the 800, probably, maybe somewhere else, okay? But there's the death certificate, there's the copy of the grave marker. I mean, that's evidence that Ricky Atwood's not with us anymore. There was some mention about the handwriting sample. I think the first question you got to ask yourself, when you really get down to it, is like, why would someone disguise their handwriting when asked to provide a sample by law enforcement? And it doesn't take a rocket scientist to figure out, well, you're disguising your handwriting and there's a state trooper in front of you and he's asking for a sample of your handwriting. He's got a judge's order that says you got to give it. It's probably not a great day for you. You probably don't want your handwriting associated with whatever that trooper is investigating. Okay, I mean, just, if you're thinking of your own self-interest here, that's the reality of it. Okay, so why would a person disguise their handwriting? Well, because it's evidence of their guilt. It is evidence that they don't want to be associated with whatever Dick Miller was investigating at the time. Okay, now, Ms. Smolders, and on behalf of her client, Mr. Snell, suggested to you here just 30 or 35 minutes ago. Remember, she can't give you evidence. I can't give you evidence. Ellsworth Stay, Dan Gunderson can't give you evidence. Okay, we're not. But I mean, what she was suggesting to you is, we don't know what happened during the 2 hours that Dick Miller was with Roy Snell when he collected the handwriting samples? Well, no, we do, because it was read to you and his testimony was preserved. And it goes like this, and I'm on page 106, line 4. Question by Mr. Gunderson. When you took that handwriting sample, was there anything unusual about that interaction? Answer, yes, sir, there was. Question, what was unusual? Answer, the behavior of the defendant filling out the form. Question, what was unusual about that behavior? Answer, it took us 2 hours to get those 2 sheets of paper. Myself and Detective Jack Waver was with me, and he was copying the different type of letters in different parts of the handwriting exemplar. Very painfully slow. It took us 2 hours to get what we got, and it was style-wise, it was obvious to me that he was trying to disguise his handwriting. So Ms. Smolders up here 30 minutes ago, we don't know what happened when Dick Miller was getting those samples. He could have been talking, he could have been non-cooperative. No, we know exactly what happened because Dick Miller testified to it at the preliminary exam and was subject to cross-examination. So no, we do know what happened. There was the reason it took 2 hours is because that was Roy Snell being cute with Dick Miller back in 1985 when he was in Kent County Jail. No, I'm not going to give you what you want. In fact, I mean, look at some of these things that he didn't want his handwriting to be connected with a Gateway registration card because he knew that's where he left Atwood's Trans Am. And Snell's connection to the Trans Am and the physical evidence in the car shows where he killed Atwood inside the car. He uses his use of the false name on the registration card is more evidence of his guilt. When you use a false name, I mean, why are you using a false name? Because you don't want people to get back to you. You don't want people to be able to track things back to you. His attempt to disguise his handwriting is evidence of his guilt too. I mean, here's the card that Roy Snell doesn't want to be associated with because at the end of the day, it does 2 things. Number 1, ties him to the Trans Am that's towed from Mr. Vanderwoody's shop from the Gateway. And number 2, the phone calls that go to his father's home and his girlfriend's house. There's nobody else on the planet that's going to go into room 20, call Roy Snell's dad and Roy Snell's girlfriend except Roy Snell. Okay? And then just look at, you heard Dick's testimony here. Very painfully slow. It took us 2 hours to get what we got. I mean, just look at these letters and how Snell did that while he's in the Kent County Jail and Dick Miller's there. I mean, who writes like this and who makes an R like that? Or, look at how these things are done. Nobody, and by the way, notice that his date of birth is in block form 2, 3/6/65, Roy Snell. And remember Scott Nibbling, the lieutenant from the Kent County Jail. They only had one Roy Snell, just in case anybody thinks otherwise, and with one date of birth of 3/6/65. And that guy was in cell 5, and he's the guy that Nolan Gant paired up with and talked to. Okay, nobody writes like that. So it's a suggestion to you that in some way that, and this is the bottom half of it too, the 28th of February 1985 in the bottom there. Okay, so he doesn't want to be associated with the Gateway Motel. That's why he writes Mike Roberts on the card. He didn't think Dick Miller would get a search warrant for Michigan Bell, find out who the subscribers were, the people who owned telephone numbers that were called from room 20, and run that to the ground like Dick Miller did. But that's what happened. So the Gateway Motel, Mike Roberts called for the tow. That was Dick Miller's testimony to you. Mike Roberts called for the tow. So the person who called for the tow is probably the same person that filled out the card and is staying in room 20, and that's Roy Snell. Mr. Zantos testified that he towed the car on August the 11th, 1983. You know, a case like this needs to have a timestamp or a time anchor, as I call it. Deb Kane was very clear. August 10th, 1983 was the last time that Ricky was seen by her, okay? And then August 22, 1983 is when Karen Atwood goes and reports him missing to the police, okay? So Deb Kane's a very good timestamp. And let's just back up here a little bit here too. I want to show you the registration again. There, you know, look at the card for the registration card for the Gateway, 8/10/83. Okay, that's the last date that Deb Kane saw Ricky Atwood alive. Okay. I mean, how do you get away from that? The phone calls to his dad, his parents' house, his dad's house, in the room called his girlfriend. I mean, that's who was in the room. The only one guy who had motive to call those two people. And if you look at the log, they're like one call after another, like 9:00, 9:52, and 10:01 p.m. Okay, let's talk a little bit about the physical evidence from Trans Am, because apparently part of the theory is by Ms. Smulders on behalf of Mr. Snell is that we don't know, and this could have been a combination of events that led to this much blood being in the car. Okay, I mean, that was part of the theory that she was just offering you. Is an innocent explanation. Don't take that brick out of the wall, start aside, don't think about it again. No, there was a bloodletting in the car, according to Glenn Moore. That's his words, not mine. Testimony. And you think about, you know, anybody who's old enough to know what, you know, a car with a hump that goes through the vehicle looks like. The hump has the drivetrain, you know, the shaft that drives the wheels in the back. And the hump is carpeted. Okay, it is a carpeted surface. You'll see from the pictures. How much blood has got to come out of Ricky Atwood's right abdominal area to go down the seat, down the hump? Remember, the carpeting is absorbent on some level, and then move by gravity, according to Glenn Moore, to the back of the car and the rear passenger footwell and pool up back there. Okay, how much blood's got to come out like that? I mean, is that the kind of an event where you're saying, yeah, I can see where that could have happened over 2 or 3 different, you know, possible events? No, it's not. I mean, if you heard Glenn Moore's testimony, you're going to see the picture, or you saw the pictures of the car. And, you know, Glenn Moore said something really important. He said, and you know, the guy's been around a while. He's like, no, finding a blood stain takes a little skill, okay? You know, identifying a blood stain, especially on I mean, the colors are, you know, subjective, but I mean, when you think about the color of Ricky's car, I mean, I would call it some type of like burnt, you know, brownish colored car. And, you know, blood on that surface, that color surface, like on the hood scoop, is going to be harder to identify. And there was no testimony from anybody at Mr. Vanderwoody's shop that they looked in the trunk. In fact, I think Mr. Vanderwoody said that they did not. Okay, so then you got Glenn Moore telling you, no, you know, finding a blood stain does take some skill, especially if it's dried a little bit, okay? And remember, they towed the car on the 11th, okay? They're not interested in the carpeting of the car. I mean, the call that comes to them, you know, think of it, you know, if you own a gas station, you get a call for a tow. Yeah, what's the matter? I don't know. It won't start. Okay, we'll get over there. We'll check it out. No, you're not looking at the carton. You're not looking at the area between the driver's seat and the drivetrain hump to see if there's blood down there. I mean, really, when you're towing the car, you don't even really have to hardly get in except to get it in neutral so you can get the thing on the hook. But in terms of when you get back to the station, it's not like you'd expect Matt Zantos to say, you know, I carefully inspected this car for blood stains. I mean, it's not his job. It's not in his wheelhouse. And even if he had looked, he may not have seen what, what eventually became the bloodstains. And how do we know they're bloodstains? It's because Glenn Moore clipped them and, they wound up with Katie Meredith, and it's guess whose blood? It's Ricky Atwood's. I mean, at the end of the day, it's not that complicated. There was kind of an attack on, the DNA evidence, and I'll get to that in a moment here. But in terms of, the cigarettes that were in the car, again, it cooled down the side of the drivetrain and got into the back footwell. That's a lot of blood. And then ask yourself this, no one here says, yeah, we're in jail together, we're commiserating, and he tells you what Roy Snell told in the Kent County Jail. Shot the guy a couple times, I'm gonna go to this one in the second year, and then kind of surprised he didn't die, shot him some more. I mean, you think about that kind of wound right here, what the result would be if you're in the driver's seat, bucket seat of a Trans Am, 1975 Trans Am, yeah, that's where you're gonna leak out. It's gonna go to the right side of the seat, down the pump, okay? The cigarette butts in the ashtray by Miller, they all had Snell's DNA on them. And yeah, there's minor contributors, and minor contributors can happen through a different, a host of different ways. One of them is somebody else smokes it. Well, maybe he shared a cigarette with somebody in the car, I don't know. But the explanation that the 6 cigarettes that have his DNA on it are in some way, they're innocently, and Ricky Atwood, just was out using the telephone for a quick minute while he smoked 6 cigarettes, that doesn't make sense. Now, Rick Atwood was pretty fastidious about his car. I mean, we heard that from multiple people, that he kept it in very good condition. He didn't let people smoke it. He didn't let his sister smoke it. I mean, he's gonna let Roy Snell, and if he did come back and find him smoking 1 cigarette, he'd be like, dude, you can't smoke in my car. He's not gonna let him keep smoking. The reason there's 6 cigarettes in there is because after he killed Rick Atwood, put him in the trunk and went out and buried his body somewhere, he started smoking, okay? And maybe he had a friend in the car, and somebody who had nothing to do with the murder, I don't know. I don't have to prove that. Not every fact and circumstance has to be proven, okay? But we know that there are 6 cigarettes with his DNA as the major donor, okay? Atwood's blood and liver cells and the globule found in the trunk by Miller. I mean, that's what you do after you shoot a guy 5 or 6 times, because you know why you're doing it. You're doing it to rob him. I mean, in human nature, we do not do things by mistake as a species very often. Okay, we typically, our behavior is modeled after motivation. We want something, we're going to figure out how to get it. I'm thirsty, I'm going to go to the kitchen and get a drink of water. I'm hungry, I'm going to go to the refrigerator, I'm going to get some food. I think this guy's got some money and some weed, and I like his car, I'm going to take it by force, okay? I mean, it's not a mistake that there's liver and his DNA, Ricky Atwood's DNA with the liver cells in the trunk. As I said earlier, Atwood's got a truck, he's a young guy, he hunts and fishes a lot. He is not putting dead animals in his Trans Am. Walter Sanders, when we talked about in voir dire, I asked all of them, I said, hey, listen, can you wait to make your decision until the end of the case? Because the last witness or last piece of evidence might be the most important thing that you hear. I told you I didn't think that was going to be the case in this case, but my point was leave an open mind during the pendency of the case. And we all promised you'd do that. And you know what? Walter Sanders is, an example why we do that. Because Walter Sanders gets done testifying, and like I said, he's not a sophisticated person, probably not real well educated. He comes up against a lawyer in cross-examination. I mean, that can be a handful. Okay. But Walter Sanders was pretty clear that, hey, I was in the car with Roy Snell, and that's corroborated by Walter Felix. He also testified that Felix did, that he learned Atwood was missing shortly after seeing him at the White Cloud High School with Roy Snell and Walter Sanders. Okay, so we get back to Deb Kane. Deb Kane is a real good time anchor for when Ricky Atwood was killed and when he went missing. August 10th, 1983, it's a day that will live in infamy for her. She'll never forget it, okay? Okay. Walter Philo says, yeah, I mean, when Ricky Atwood went missing, there was a big deal around town. The last time I saw him was when it was Roy Snell and Walter Sanders in his Trans Am. He was getting ready to rain. He didn't like to drive the car around the rain. The air scoop was off and had a normally aspirated carburetor. And, he didn't want to drive in the rain because the rain might get in the engine, okay? So, the last time I saw him, they were driving down Wilcox East towards M37. Sounds pretty similar to what Walter Sanders testified to. My point is when you get done listening to Walter Sanders, if that's all you got, you'd be going, tough, tough to rely on that one person to get me past beyond a reasonable doubt. Nope, you don't have to. Because as we talked about, if a witness's testimony is corroborated by other evidence, testimony or exhibits in the case, then that witness's testimony becomes more believable, more reliable, more credible, okay? So Walter Sanders, you get done listening to him and just if that was all you heard, you might have reservations. But then we hear from Walter Philos and it's like, Walter Sanders was in the car with Roy Snell and Ricky Atwood. Snell asked Sanders if he wanted to help rob Atwood and showed him a pistol. Sanders has been consistent about that throughout, okay? And remember, Sanders and Gant don't know each other and have never met. Okay, why is Ralston talking about that now? Because it kind of gets back to this independent verification, if you will. Okay, Sanders and Gant don't know each other, okay? Yet their testimony fits together, okay? Their testimonies support each other even though they've never met, okay? Because the story that Nolan Gant tells you during his testimony is supported to a certain extent by Walter Sanders and vice versa. Okay, so, we don't take the bricks out of the wall one at a time and look at them. We look at the whole map, we look at the whole picture. Okay, so keep in mind that Nolan Gant doesn't know anybody from Newaygo. Let's talk about J.B. Martin for a minute. First thing is they grew up together. Snell and Mr. Martin are childhood friends. Okay, literally. And, Mr. Snell came up here a little bit later in life than Mr. Martin did. But, he comes up from Cincinnati. He's up here to live with his dad. He's living with his mom down in Cincinnati. And then he comes up here to live with his dad. And JB and him get very close, okay? And I think you all took that in. I mean, you heard JB talk about the 800, how he called it paradise. And, it was an important place to him. The Snell family, when he was 13, 14, 15, were probably important people to him. It's a place where he could stay, he could get a meal, probably cared for in some way. Hey, Sonny, how you doing? I mean, probably more attention than he got back at home with, the number of siblings that he was competing with. And I don't besmirch Mr. and Mrs. Martin, his mother and father in any way. I'm just saying that, the situation as it existed for JB and Roy Snell, when Roy Snell came up here, moved up here from Cincinnati and then they got together. And then you look at JB's circumstances and kind of what was available out on the 800. I mean, that's like a found opportunity. I mean, that's for JB Martin, that was probably a very positive aspect of his life. Okay. It was not easy for JB to come forward and tell you what he told you. Okay. Snell's father, Mr. Snell's father, as J.B. Martin testified to, was somebody that J.B. Martin feared a little bit. Okay, probably a little bit like his own dad when you think about it. I mean, he's 13, 14, 15 when they're growing up. There's Mr. Snell Sr. And through the years, got, achieved some level of respect with J.B. Martin. Okay, and, you heard Mr. J.B. talk about, no, that was a guy to fear. I mean, Roy Snell Sr. was a man to fear. Okay. There's JB at his own parents' house, and Roy Snell stops by because Dick Miller is interviewing people around town. And one of the people that Dick Miller has interviewed is J.B. Martin, okay? And remember what J.B. Martin told you about what Mr. Snell Senior said, you know, we love you, but you gotta keep your mouth shut. And that's what Roy Snell Senior said, J.B. Martin, when he called him. He says, Sonny, we love you, but you gotta keep your mouth shut. And, okay, so the visit by, to Snell, okay, Ms. Smulders, on behalf of Mr. Snell, suggests that JB is one of the liars. Remember, JB's a liar, Nolan Gant's a liar, Walter Sanders a liar. They're all lying. I mean, she said that to you at different times during her statement, but, you know, and then you gotta step back from that first and say, wow, that's really unfortunate. That's an unlucky situation where you get three unrelated people all lying about you killing somebody, okay? I mean, you know, that's a very, you know, that would be a very unfortunate circumstance if it were untrue, but that doesn't happen in life. Three witnesses who don't know each other don't get together and somehow all concoct a story along with supporting physical evidence that tells you who the murderer is, okay? And think about, you know, when Snell is telling Martin, yeah, I killed him. If I hadn't, someone else would have. Who would you tell? You know, well, you might tell somebody who he's over their front. I mean, that's just the only way to say it. When Snell comes over to Martin's mother and father's house, he's issuing him a warning. When you heard JD say, no, he invited me to go to the 800. I didn't go that day, didn't go any other day after that. Okay. But that's the kind of guy that Snell is. I mean, he's going to go over and front you a little bit and say, no, if you know what you're doing, keep your mouth shut. And that's what the father said. And that's the kind of person that you would do that to, somebody you grew up with and had a little bit of trust. Think about what Snell told him when they were, when he got up there from Cincinnati. Yeah, rob the dope dealer and never leave your name behind. Those are two lessons that Snell came up from Cincinnati with. And also, the girl from Grand Rapids, I mean, hey, where's that bad ass Trans Am you were driving? Just a random, or actually not even a random, it's what we would call a spontaneous statement. Hey, where's that car you had? Snell doesn't answer the question in any sense because he doesn't want to be tied to the Trans Am. Okay. One of the things Ms. Mulder said to you is that J.B. Martin has been all over the place. Well, he hasn't really, because this is what he told Dick Miller in his own handwriting in 1984. This is October 26, 1984. Roy Snell Jr. said, yeah, I killed him, but if I wouldn't have, someone else would have. And there were a lot of people standing in line. I wasn't the only one involved in it. There were 4 older people who knew how to keep their mouths shut. Rick's probably in someone's sausage by now. That's not made up. That's not fabricated. He doesn't want to be pointing the finger at Roy Snell any more than he'd want a root canal. I mean, it's not somebody that he wants to mess with. It's somebody he grew up with, and it's somebody whose father he fears. Let's talk about Nolan Gant. I told you earlier, what we say isn't evidence. What I say, what Ms. Mulder says, not evidence, okay? This isn't evidence. In her presentation, she had on her screen that in 2018, Nolan Gant didn't remember the event. That was her argument to you about an hour ago. Right up there on the screen, 2018. No, probably another mistake. But at the end of the day, In 2018, Nolan Gant testifies under oath at the investigative subpoena. And let me read you some of that was read. Remember when Nolan Gant was cross-examined, and I went back and I asked him some questions about what he testified to at the investigative subpoena hearing. Let me remind you of what his testimony was, and this is why what the lawyers say is not evidence. From page 16, starting on line 8. Question, okay, in your own words, tell us what Roy told you about that, understanding that he told you in bits and pieces, and as you say, tell us, what story was it that you know? Answer, he told us that. Question, told us or you? Well, answer, well, me. Yeah, he told me that he killed a guy and that he robbed him. He called the guy over because he was staying at a motel, him and his girlfriend. Question, did he say where the motel was? Answer, no. Question, what city? Answer, it was in Grand Rapids, I think. Question, okay, go on. Answer, but he called the guy over and the guy came. Question, the guy he killed? Answer, the guy he killed. And he robbed the guy. He said the guy, I think they was dealing with each other as far as drugs and money and things like that. And he said the guy looked at him a certain way, and when he was in the car, and I think they had some type of argument. I'm trying to remember. Question, did he say what kind of car he was in? Answer, I know it was a sports car, a Trans Am or something like that. I know it was a sports car. There's 36 pages of sworn testimony by Nolan Gant in 2018. And in less than an hour ago, Mr. Snell's attorney suggested that in 2018, Nolan Gant claimed to not remember anything because he hadn't been given anything. Remember, the letter that he's getting from our office, from my office, is really all that we would be duty bound to report this. If the Tennessee Department of Corrections called and said, hey, did Nolan Gant testify for you? Yes. Question, what was the case about? It was a homicide. Next, third question. Was his testimony consistent with the other evidence in the case? Yeah, it was. Okay. What was the verdict in the case? And then I would provide the verdict. Okay. I would be duty bound to answer that phone call. He's really not getting very much out of that other than an accurate report as to what he did while under oath. Okay. It's not like he got some free to get out of jail card. Okay. And also keep in mind, J.B. Martin tells you, yeah, I came to my parents' house, told me, yeah, I killed him. If I didn't, somebody else would have. It's probably in someone's sausage by now. J.B. Martin doesn't know Gant, okay? And Gant has no means to know about the physical evidence in Mr. Atwood's Trans Am. And you heard Detective Rios today testify about that. He said, yeah, there's a search warrant, but very general, and no, couldn't get the specifics about what was in the trunk, what was in the car, where the blood was found, things like that. Okay? And Mr. Atwood's race is not in the search warrant. The fact that he is Caucasian is not in the search warrant. Yet Nolan Gant knows that the person that was killed was a white guy. Okay? The only way he could have known that is from Roy Snell. The blood on the right side of the driver's seat, pooling that goes into the footwell, corroborates Gant's testimony to you when he tells you about how he died, okay, by Roy Snell shooting him while he's in the passenger seat. That corroborates Gant's testimony, the physical evidence does. And again, what Gant received is what we would have been duty bound to report anyways. And his testimony to you is perfectly consistent with his 1985 statement to Dick Miller, which is Exhibit 66, okay? And let's kind of hard to see. I met Roy about, I'll say, this, and remember, this is March 4th, 1985. And you bet he called up looking for a deal back then. Just got done stabbing a guy or whatever it was he was in for, Nolan Gant, trying to help himself out. And that's what we as humans do. I mean, we act primarily on our motives. He's in jail. He knows he's facing some prison time. Yeah, and that's the guy who's going to try to help himself out a little bit. Doesn't mean he's a liar, okay? And what does he say? He says, yeah, this is the recorded interview from with Dick Miller on March 4th, 1985 at the Kent County Jail. No, he's not in the cell with him, with Roy next door. Gant, I met Roy about, I'll say 2-3 weeks ago. We got to talking as being friends. I'm in cell 5, he's in cell 4. Remember Scott Nibblink, and what he testified to. They were exactly in those cells. We got to talking each day about things we had done in the past. A murder, this murder that I'm talking about now, that he committed. He told me why. He killed a guy for his money. He was staying at a motel. He called the guy up. Guy came and picked him up. He drove up. Then he told me that he shot the guy, must be 6 times. Took the guy out of the car, took all his money and dope, threw him in the trunk, drove the car away. When he drove the car away, he went and buried the guy on private property. Then he left in the car and the car blew up. And the car blew up. He called the tow truck to come pick up the car. He buried the gun from the body. I don't know where he buried it at. And that's, the first paragraph with the interview of Dick Miller. I mean, either Nolan Gant is clairvoyant and knows things that, through some other means that I'm not aware of, or he talked to Roy Snell. Okay, and this is very telling here. This is Gant's explanation to Miller on March 4th, 1985, about Roy Snell describing shooting Rick Atwood in the car, and it has a ring of truth to it. Let's read it together. The guy he said the guy stopped, and he said he just looked at the guy and shot him. And when he shot him, the guy just looked at him like he was shocked or something. Then he said the guy bitten down, came up, and he said to himself, this motherfucker's not going to die, and shot him again. And then he just kept shooting him. And after he killed the guy, he dragged him out of the car, took all his money and dope and things, and put him in the trunk. Does that ring true to you? Or does that sound like somebody just making it up, whole cloth? I'd suggest that's evidence of a very truthful statement there. Did he say how long ago this happened? Okay. In 1985, Roy Snell would have been about 20 years old. He would have been celebrating his 20th birthday because he was born in 1960. Nolan Gant's statement to Dick Miller about when this happened, according to, what did Snell tell you about when this happened? Could have picked any year between 1965, actually could have been one, but I mean, several years in there he could have picked Nolan Gant if he didn't really know. 1983, okay? He's right. And the reason he's right is because the guy that killed him talked to him and told him what he did. Did he tell you where the motel was located? No. What city? I think Grand Rapids. Talk a little bit about Gail Rushlow. The reason we had to call Gail Rushlow is not because she was going to point the finger and say, yeah, that's the guy from 1983 that I remember being in the chocolate brown Trans Am that pulled up with blood all over it. No, and she was the record keeper for the Gateway Motel. And by the record keeper, I mean somebody who could establish, yes, this is what a registration card looked like. This is what our call logs look like. This is how we did it. I mean, in order for us to bring this in and for this to get to you as evidence, we have to have a custodian or somebody that's familiar with the process to explain it. I mean, otherwise, it's like, what's this? We don't know. I mean, there's no foundation for it. The chain of custody issues is what was talked about a little earlier. And what Gail Rushlow does tell you, though, is the process for, how these calls get made. Now, and again, what I say is an evidence and things that Ms. Smulders says on behalf of Mr. Snell is an evidence. And one of the things that Ms. Smulders did during her closing argument up here was she made an assumption, like back in 1983, I mean, who would ever go through this process of, going into a hotel and giving a fake name, and then everybody knew back then how the telephone system worked in a motel. I don't think that's true. I don't think that's a correct assumption. I mean, she's trying to make that argument on behalf of Mr. Snell, but no, back in 1983, not everybody knew how a hotel telephone system billing worked. Okay, and to suggest in 1983, when he was 18, Mr. Snell was, that he perfectly understood it was a mistake. Okay. In terms of DNA, the blood could have come from more than one event. I don't really think the evidence supports that. Environmental factors, Joel Schulte and Ms. Meredith were very clear that no, if there's something like heat, if the DNA isn't there, I can't get a result. I'm not going to get a mistaken result that accidentally points to somebody from Newaygo County back in 1983. Okay, the DNA factor and the DNA evidence is what it is. In terms of since they didn't find the body out on the 800 or any of their other searches, that obviously what Nolan Gant said isn't reliable. Nolan Gant didn't say where he buried the body, but it was on private property. And yeah, I think it is reasonable to assume it was up on the 800. But let me say this, it's a big county. And if you got 800 acres of it, that's a fairly good, that's 10 sections. And, to suggest that, well, they went out there and searched, so we know the body's not there, that's flawed logic, is my position, is my thought. Okay. Let's talk a little bit about Mr. Snell's rules, what they are. Never leave your name behind. Okay. And that's smart. For him, it's not smart it's not good if you're his victim, but if you're thinking like a survivor, then that's a good way to roll. That is. And rob the dope dealer. They won't call the cops. Got to hand it to you, Mr. Snell. Yeah, that's good logic. That's smart. I mean, if you're going to be a robber, don't rob the bank. The bank has cameras and employees who are reliable, and they'll come in and testify against you, and police are probably somewhere in the neighborhood, and you might just get caught. No, you robbed a dope dealer, much less likely to get caught. And this is J.B. Martin telling us this. The person he grew up with. This is one I just couldn't get away from. There they are. They're in the Kent County Jail. It's 1985. There's Dick Miller. Got a search warrant for you. Judge says you got to give me a handwriting sample. Tell J.B. keep his mouth shut. That's what comes out of Snell's mouth, Dick Miller, through his sworn testimony to you, that was read to you, when he presents Roy Snell the search warrant to compare his handwriting to the registration card at the Gateway Hotel. Tell JB he got to keep his mouth shut. I'm going to leave you with this. It's a little bit of the circle of truth is what I'm going to call it. And all these things are independent of one another, and all these things point to Roy Snell as being the man who murdered Rick Atwood back on August the 10th, 1983. First night at the top, we'll start with J.B. Martin, in the statement that is in Exhibit 66. Yeah, I killed him. If I didn't, somebody else would have. Nolan Gant. Yep, I don't know, those two don't know each other. JB and Nolan, they're independent. You know, this is how, you know, you look at the wall and you can't take the bricks out of it. And Nolan Gant doesn't know Walter Philos, right? And Walter Philos says, yeah, I saw Walter Sanders in the car. The last time I saw Ricky Atwood. And what does Walter Sanders tell us? That Snell wanted to rob Atwood that very day. He showed him a gun. The physical evidence in the car and, you know, Snell's attempts to disguise his handwriting. The independence of the evidence against Roy Snell that he's the person that is responsible for Ricky Atwood's death is far beyond a reasonable doubt, okay? And a couple of things here, and I'm just about done. The judge is going to give you instructions probably tomorrow morning, if I had to guess, on this case, and we've talked about them a lot from board year on. And one of the instructions she's going to give you is you're going to have the choice between felony murder and a less serious crime, second-degree murder. Okay, and felony murder is the crime that Roy Snell committed when he killed Ricky. Because what he did was felony murder, as I talked about, I think in board year opening, is second-degree murder plus. Okay, plus what you ask? Plus another felony, larceny or robbery. Okay, so if you kill somebody while you're committing second-degree murder, and you're also you're robbing them or thieving from them, now you're up to felony murder. You've committed second-degree murder while committing another felony. Okay. Okay, so that begs the question, okay, what's second-degree murder? You intend to kill the person? But first of all, you cause someone's death. All right, and then you have a certain state of mind. You either intend to kill the person, intended to kill, you intended to cause great bodily harm, or you intended to create a high risk of death or great bodily harm. That's second-degree murder. Okay, that is causing the death in one of those three states of mind. Okay, now you do that while you're robbing the guy. Now you're felony murder. Okay, when you think about human nature, and you're allowed to bring your life experience into the jury room with you, you don't check it as a piece of luggage outside. We do things for reasons in life. There's very little that we do that is done and accomplished by mistake. We might make a mistake, but that's different. I'm talking about where you do a task and you accomplish something, you go, oh, I made a mistake by doing that. I mean, as a people, we don't typically do that. Okay. The reason Ricky Atwood was victimized by Roy Snell is because he was the weed dealer. And he, you know, that's a better person to rob than the bank owner. Okay. And by victimizing him, he followed through on what he told JB Martin, which was, you know, rob the dope dealer, don't leave your name behind. And second-degree murder, a conviction for that would ignore what happened that day, what he told Nolan Gant, and what he told JB Martin about why he did what he did. You know, if I didn't do it, somebody else would have. There were people standing in line to get at that guy. Okay. The less serious crime of second-degree murder is not. I mean, this is a felony murder case, okay, because it was done during the course of a robbery or a larceny. The less serious crime of second-degree murder, although it fits, it doesn't take into account all the facts of this case. Okay. A couple of the other instructions that Judge Dykeman will give to you tomorrow is punishment should not be a consideration for you. Okay, the court will sentence the defendant in the bounds of the law based on your verdict. Okay, when you think about it, I mean, the last person to be seen with Ricky Atwood was Roy Snell, and he made his own choices. He put himself where he sits today. Okay, he's not a victim here. He killed another. That's why he sits here today. In fact, I mean, the reason why you sit here today is because of him. I mean, and what he did that resulted in this trial. Okay, he made his own choices, and the judge will tell you that don't worry about sentencing. That's not anything you should be concerned with. Okay, punishment is up to the court. On behalf of Mr. Stay, Mr. Gunderson, Mr. Rios, the entire Atwood family, myself, I can't thank you enough. Okay, I mean, I know this is an arduous process, and I get it, but it's an important matter. And we have proven beyond a reasonable doubt that back in August of 1983, Roy Snell committed a robbery homicide when he shot and killed Ricky Atwood in his own car, stole his car from him and whatever other property he could find, including his weed and money. And he took him and buried him somewhere that Ricky's family has never been able to find their loved one. Okay? We've proven this case beyond a reasonable doubt. That's what the charge is. Okay? We're going to ask you to return a guilty verdict, felony murder, and felony firearm, both counts. And again, we're very grateful for your time. Thanks, folks.
As you guys have come to learn, time has kind of gotten away from us this afternoon. You've heard all the evidence, you've heard all the arguments, but I have to read you what they kept referring to as the jury instructions. That is going to take some time, and I don't think we want to do that tonight. So I'll have you come back on Wednesday, and we will do jury instructions, and then you'll be able to deliberate. So between now and then, same instructions. Not to discuss the case with each other or anyone else, not to look up anything or read anything on social media. When we come back, we'll come back on Wednesday. It'll be a little bit later on Wednesday. I have a matter I have to take care of first thing in the morning. So if you want to get here about 10 to 9, we'll try to go right on the record at 9 o'clock and begin. So a little bit later on Wednesday, but still the same routine. You'll come in and check in and go to the jury room. Jury. I appreciate y'all coming back today. I know this morning's drive may have been a little sketchy for some of you, so I'm glad y'all made it here safely. Counsel, anything before I begin instructions?
No, Your Honor.
No, Your Honor.
Ladies and gentlemen of the jury, as we talked about the last time we were here, you've heard all of the evidence and arguments in this case, and now I'm going to read you the jury instructions. You will get a copy of all of these when you leave to deliberate as well. Members of the jury, the evidence and arguments in this case are finished, and I will now instruct you on the law. That is, I will explain the law that applies to this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of other jurors, who may have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of the case are. This is your job and nobody else's. You must think about all the evidence and then decide which piece of evidence what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I have already given you some instructions about the law. You must take all my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum it up, it is your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way, to decide the case. A person accused of a crime is presumed to be innocent. That means you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. Every defendant has the absolute right not to testify. When you decide this case, you must not consider the fact that he did not testify. It must not affect your verdict in any way. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not. Evidence includes only the sworn testimony of the witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence. You must be careful not to consider them as such. I will now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. Likewise, the fact that he is charged with more than one crime is not evidence. The lawyer's statements and arguments and any commentary are not evidence. They are only meant to help you understand the evidence and each side's legal theories. You should only accept things that lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses, your questions to the witnesses, and my questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, summary of the evidence, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give an instruction, I am not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide the case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I have excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decisions only on the evidence that I let in and nothing else. Your decision should be based on all the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence. But you should not use any personal knowledge you may have about a place, a person, or an event. To repeat once more, you must decide this case based only on the evidence admitted at this trial. As I said before, it is your job to decide what the facts of the case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have and not be influenced by a witness's disability, gender, identity, race, religion, ethnicity, sexual orientation, age, national origin, or socioeconomic status. Again, take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age and maturity affect how you judge his or her testimony? Does the witness have bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, or suggestions or other influences that might have affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in this case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about the testimony, which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. The prosecutor must also prove beyond a reasonable doubt that the crime occurred on or about August 10, 1983, within the state of Michigan. When you go to the jury room, you will be provided with a written copy of the final jury instructions. You should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a businesslike way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communication equipment until we recess. A verdict in a criminal case must be unanimous. In other words, to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately, each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It is your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you, or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. I have already given you instructions regarding a lesser offense. As to any count, which includes a lesser offense, you must consider the principal offense. If you all agree that the defendant is guilty of that offense, you need not consider the lesser offense. If you believe that the defendant is not guilty of the principal offense, or if you cannot agree on that offense, you may consider the lesser offense. It is up to you to decide how long to consider the principal offense before discussing the lesser offense. You may go back to consider the principal offense again after discussing the lesser offense if you want. If you have any questions about the jury instructions before you begin deliberations, or questions about instructions that arise during deliberations, you may submit them in writing in a sealed envelope to the bailiff. Members of the jury, one of your fellow jurors was unable to continue the deliberation with you. Do not consider the reason for the juror's discontinued service. Possible penalty should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by the law. If you want to communicate with me while you are in the jury room, please have your foreperson write a note and give it to the bailiff. It is not proper for you to talk directly with the judge, the lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. When you go to the jury room to deliberate, you may take your notes and full instructions. If you want to look at any of the relevant documents or exhibits, those will also be available to you. When you go to the jury room, you will be given a written copy of the instructions you have just heard. As you discuss the case, you should think about all my instructions together as the law you are to follow. The defendant is charged with 2 counts, that is, the crimes of homicide, felony murder, and weapons, felony firearm. These are separate crimes, and the prosecutor is charging that the defendant committed both of them. You must consider each crime separately in light of all the evidence in the case. You may find the defendant guilty of all or any combination of these crimes, or not guilty. I have prepared a verdict form listing the possible verdicts. It reads, Defendant Roy Snell, possible verdicts. You may return only one verdict on each count, and you will mark one verdict for each count. Count 1, homicide, felony murder, not guilty, guilty of homicide, felony murder, or guilty of the lesser offense of homicide, murder, 2nd degree. Count 2, weapons, felony firearm, not guilty or guilty of weapons, felony firearm. The prosecution has introduced evidence of a statement that it claims the defendant made. Before you consider such an out-of-court statement against the defendant, you must first find that the defendant actually made the statement as given to you. If you find that the defendant did make the statement, you may give the statement whatever weight you think it deserves. In deciding this, you should think about how and when the statement was made and about all the other evidence in the case. You may consider the statement in deciding the facts of the case. Facts can be proven by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that is direct evidence that it is raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So, for example, if you see a person come in from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it is raining. You may consider circumstantial evidence. Circumstantial evidence by itself, or a combination of circumstantial evidence and direct evidence, can be used to prove the elements of a crime. In other words, you should consider all the evidence you believe. You have heard evidence that before the trial, witnesses made statements that may be inconsistent with their testimony here in court. You may consider an inconsistent statement made before the trial only to help you decide how believable the witness's testimony was when he or she was testifying here in court. If the earlier statement was made under oath, then you may consider the earlier statement as evidence of the truth of whatever the witness said in the earlier statement when determining the facts of this case. When the lawyers agree on a statement of facts, these are called stipulated facts. You may regard such stipulated facts as true, but you are not required to do so. You may consider whether the defendant had a reason to commit the alleged crime, but a reason by itself is not enough to find a person guilty of a crime. The prosecution does not have to prove that the defendant had a reason to commit the alleged crime. They only have to show that the defendant actually committed the crime and he meant to do so. The testimony of Karen Atwood and Detective Richard Miller was read into this trial because they are not available. This testimony was taken under oath at an earlier hearing at which an attorney for the people and an attorney for the defendant was present. You should consider this testimony in the same way you consider any other testimony you have heard in court. The defendant's intent may be proved by what he said, what he did, how he did it, or by any other facts and circumstances in evidence. You should not decide this case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. You have heard that a lawyer talked to one of the witnesses. There is nothing wrong with this. A lawyer may talk to a witness to find out what the witness knows about the case and what the witness's testimony is. You have heard testimony from several witnesses, Joel Schultze, Mark Goff, Dr. Stephen Fole, Catherine Meredith, and Bruce DeCracker, who have given you their opinions as an expert in their fields. Experts are allowed to give opinions in court about matters they are experts on. However, you do not have to believe an expert's opinion. Instead, you should decide whether you believe it and how important you think it is. When you decide whether you believe an expert's opinion, think carefully about the reasons and facts they gave their opinion and whether those facts are true. You should also think about the expert's qualifications and whether their opinion makes sense when you think about the other evidence in the case. You have heard testimony from witnesses who are police officers. That testimony is to be judged by the same standards you use to evaluate the testimony of any other witness. One of the issues in this case is the identification of the defendant as the person who committed the crime. The prosecution must prove beyond a reasonable doubt that the crime was committed and that the defendant was the person who committed it. In deciding how dependable an identification is, think about such things as how good a chance the witness had to see the offender at the time, how long the witness was watching, whether the witness had seen or known the offender before, how far away the witness was, whether the area was well lighted, and the witness's state of mind at the time. Also think about the circumstances at the time of the identification, such as how much time has passed since the crime, how sure the witness was about the identification, and the witness's state of mind during the identification. You should examine the witness's identification testimony carefully. You may consider whether other evidence supports the identification, and then it may be more reliable. However, you may use the identification testimony alone to convict the defendant as long as you believe the testimony you find that it proves beyond a reasonable doubt that the defendant was the person who committed the crime. The defendant is charged with first-degree felony murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Richard Atwood. That is, that Richard Atwood died as a result of being shot by the defendant with a pistol. Second, the defendant had one of these three states of mind. He intended to kill, or he intended to do great bodily harm to Richard Atwood, or he knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of his actions. Third, that when he did the act that caused the death of Richard Atwood, the defendant was committing or attempting to commit the crime of larceny from the person or robbery. For the crime of larceny from the person, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant took someone else's property. Second, that the defendant took the property without consent. Third, that the defendant moved the property, but it does not matter whether the defendant actually kept the property. Fourth, that the defendant took the property from Richard Atwood's person or from his immediate presence. Immediate presence means that the property was physically connected to Richard Atwood or was right next to him. Fifth, that at the time it was taken, the defendant intended to permanently deprive the owner of the property. For the crime of robbery, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant used force or violence against, assaulted, or put in fear Richard Atwood. Second, the defendant did so while he was in the course of committing a larceny. A larceny is the taking and movement of someone else's property or money with the intent to take it away from that person permanently. In the course of a larceny includes acts that occur in an attempt to commit the larceny, or during commission of the larceny, or in flight after the commission of the larceny, or in an attempt to retain possession of the property or money. Third, Richard Atwood was present while the defendant was in the course of committing the larceny. In determining whether the act causing death occurred while the defendant was committing the crime of robbery or larceny from the person, you should consider the length of time between the commission of a robbery or larceny and the murder, the distance between the scene of the robbery or larceny and the scene of the murder, whether there is a causal connection between the murder and the robbery or larceny, whether there is a continuity, oh my, I did that the last time, whether there is continuity of action between robbery or larceny and the murder, and whether the robbery was committed during an attempt to escape. You may also consider the lesser charge of second-degree murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant caused the death of Richard Atwood. That is, Richard Atwood died as a result of being shot by the defendant with a pistol. Second, the defendant had one of these three states of mind. He intended to kill, or he intended to do great bodily harm to Richard Atwood. or he knowingly created a very high risk of death or great bodily harm, knowing that the death or such harm would be the likely result of his actions. The defendant is also charged with separate crime of possessing a firearm at the time he committed or attempted to commit the crime of homicide, felony murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant committed or attempted to commit the crime of homicide, felony murder, which has been defined for you. It is not necessary, however, that the defendant be convicted of that crime. Second, at the time the defendant committed or attempted to commit the crime, he knowingly carried or possessed a firearm. This charge includes possession of a firearm during either a completed crime or an attempted crime. An attempt has two elements. First, the defendant must have intended to commit the crime of homicide, felony murder. Second, the defendant must have taken some action toward committing the alleged crime but failed to complete the crime. It is not enough to prove that the defendant had preparations for committing the crime. Things like planning the crime or arranging how it will be completed are just preparations. They do not qualify as an attempt. In order to qualify as an attempt, the action must go beyond mere preparation to the point that the crime has been completed if it had not been interrupted by outside circumstances. I'm going to read that again. To the point where the crime would have been completed if it had not been interrupted by outside circumstances. To qualify as an attempt, the act must clearly and directly be related to the crime the defendant is charged with attempting and not some other objective. It does not matter whether or not the firearm was capable of firing a projectile or whether it was loaded. A firearm includes any weapon which will or is designed to or may readily be converted to expel a projectile by action of an explosive. A pistol is a firearm. A pistol is a firearm. A firearm includes any weapon which will or is designed to or may readily be converted to expel a projectile by actions of an explosive. The shape of the pistol is not important as long as it is 26 inches or less in length. It does not matter whether or not the pistol was capable of firing a projectile or whether it was loaded. Concludes the reading of the instructions. I'll ask the bailiffs to now please stand and raise your right hand for me. Do you now solemnly swear that you will, to the utmost of your ability, keep the persons sworn as jurors on this trial from separating from each other, that you will not suffer any communications to be made to them or any of them orally or otherwise, that you will not communicate with them or any of them orally or otherwise, except by the order of this court, or that you will ask if they have been agreed on a verdict until they have been discharged, and that you will not, before they render their verdict, communicate to any person in the state of their deliberations or the verdict they have agreed upon, so help you God. Thank you. You may put your hand up. All right, as you know, we had a jury of 15. We now have a jury of 14. Two of you will now draw lots, or we will draw lots, and two of you will be dismissed from the deliberations. Ms. Jamie?
Miss Sarah Ames, juror number 5, panel N 241. And Wesley English, juror number 15, panel G 124.
All right. For those two jurors, you are now free to leave. You will not be involved in the deliberation at this point in time. However, I am going to let you leave the courtroom. However, you may not discuss the case with anyone, watch anything on YouTube, or do anything until you are contacted by the court to let you know you have been discharged from the case. In other words, until the deliberations are complete, you may not discuss the case with anyone or look up anything in the case, and you may be called by staff if needed. So those two jurors, Sarah Ames and Wesley English, you may now leave.
Judge, before we excuse those two jurors with thanks, can we approach for a minute?
All right, I'm going to reread one of the instructions that I read to you just a moment ago with one correction. Couple of corrections. The defendant is also charged with the separate crime of possessing a firearm at the time he committed or attempted to commit the crime of homicide, felony murder, or second-degree murder. To prove that charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant committed or attempted to commit the crime of homicide, felony murder, or second-degree murder, which has been defined for you. It is not necessary, however, that the defendant be convicted of that crime. Either of those crimes. Second, that at the time the defendant committed or attempted to commit that crime or crimes, he knowingly carried or possessed a firearm. This charge includes possession of a firearm during either a completed crime or an attempted crime. An attempt has two elements. First, the defendant must have intended to commit the crime of either homicide, felony murder, or second-degree murder. Second, the defendant must have taken some action towards committing the alleged crime, but failed to commit the crime. It is not enough to prove that the defendant made preparations for committing the crime. Things like planning the crime or arranging how it will be completed are just preparations. They do not qualify as an attempt. In order to qualify as an attempt, the action must go beyond mere preparation to the point where the crime would have been completed if it had not been interrupted by outside circumstances. To qualify as an attempt, the act must clearly and directly be related to the crime the defendant is charged with attempting and not some other objective. It does not matter whether the firearm was capable of firing a projectile or whether it was loaded. A firearm includes any weapon which will or is designed to or may readily be converted to expel a projectile by action of an explosive. A pistol is a firearm. All right. Now, those two jurors that I mentioned earlier may now be excused with that request that you not speak or order that you not speak to anyone, talk about any of the deliberations. As soon as the jury returns a verdict, you will be notified by staff that your jury duty is over, and then at that point, you will be able to discuss anything that you want to discuss about the case. All right, so I'll have the jury go ahead and on FC. Counsel is present, as is Mr. Snell. The jury has now entered the courtroom. I've been informed that the jury has reached a verdict. Would the foreperson please rise? Madam or sir, has the jury reached a unanimous verdict?
Yes, we can.
Right, can you pass that down to the bailiff for me? Put that to Ms. Mary. Yeah, back to the foreperson. Mr. Foreperson, will you please rise and now read the verdict for me?
Count one, homicide, felony murder. The guilty find, the jury finds him guilty of homicide, felony murder. On count two, weapons, felony firearm. We find the defendant guilty of weapons, felony firearm.
Thank you, sir. You may be seated. Can you pass that back down to the bailiff? Counsel, do you wish to poll the jury?
Yes, please, Judge.
We'll start. I'm going to poll the jury now. That means I'm going to ask each one of you if that was in fact your verdict. Juror, I think you're technically number 2. Yes. Juror number 2, was that your true verdict?
Yes.
Juror number 3, was that your verdict?
Yes.
Juror number 4?
Yes.
Juror number 6?
Yes.
7, was that your verdict? Juror number 8?
Yes.
Back here, sir. Juror number 9, was that your verdict?
Yes.
Juror number 10,
Yes.
juror number 11,
Yes.
juror number 12, juror number 13, was that your
Yes.
verdict? Juror number 14, was that
Yes.
your verdict? Anything else before I excuse the jury?
No, Your Honor.
Your service is now concluded. I thank you for your service. I thank you for your patience as we navigated the different schedules. You are free to leave now. You may speak to whoever you want to speak to, or you don't have to speak to anyone about the case. If you check in with the staff before